And we're back.
All right, so we're back, and so welcome back, everybody. And for those of you tuning in to watch our work this afternoon, we're going to be looking at some working groups that were put together after our last meeting to dive deeper into some of the topics that we're exploring and potentially building legislation on. We're going to do a little bit of a change up in the agenda. So the next item on the agenda was KYC AML portability working group. We're going to go ahead and table that and move it down for just a little while we get some of our witnesses and folks from the public lined up. And so we're going to move into the number 7 on our agenda, which is Digital Identity Working Group. That is Chairman Rothfuss. So I'll let you take it from here.
Thank you, Mr. Chairman. Mr. Chairman, we've done a good bit of work through the working group on concepts of what to include. The working group is Representative Yin. We had and Joel Reville from this group, as well as Senator Driscoll. And then we also had participation by Chris Land and Christopher Allen as well in some of our conversations. And we tried to bring forward some ideas that could go into a first draft of legislation and trying to figure out what that first draft of legislation might look like and might include. There are a ridiculous number of potential components that could be included. That's one of the things that we certainly identified, and some key concepts that could be brought in, and what the right way to do that as we move forward is going to be is a bit of a challenge, and how much to bring in. One of the things that we really worked on or included in our concepts is the idea that, once again, as we've done with other statutory development, we wanted to make sure that we were bringing value through governance, that we weren't going to end up with a piece of legislation that added new restrictions and held back innovation in the space, but trying to identify what we could include in a first bill that would help to enable industry and what industry is currently trying to do across many different disciplines. So some of the concepts of what we want to make sure that we're bringing in potentially to a first piece of legislation are, first and foremost, a legal definition of digital identity that we can have in statute that is useful and meaningful, that enables industry in the same way that what we've defined previously. For example, how do you manage digital asset custody, and what do we point to in the UCC to map that out? Those types of enabling concepts. What would be enabling from a definition of digital identity? We looked at a series of different definitions of digital identity. Christopher Allen's been trying to consolidate those, and we've tried to bring a series of experts in from the legal community that have been working on digital identity, so that we can be the leader in that space. In other words, first state with a clear definition of digital identity, what that means, and what it legally represents, without being specific to any type of technology or use case. We talked also about the idea of having some Wyoming state principles with relation to these digital identities, potentially in statute, but it would be hard to give legal meaning to those without having use cases surrounding them. So there may be some that would be workable in a first draft. Others might have to wait, but some concepts there, again, are trying to put together this enabling framework that is not restrictive for industry, but again, if you meet it, if you achieve certain requirements or certain principles, then the state's going to recognize the legitimacy of that digital identity. And you can see this kind of gets hand in hand in the discussion of say the will legislation we were doing a while ago, as we start looking at what this digital identity, digital personhood is going to be comprised of. When we were talking about ways to enable it from the state perspective, right? You've got the ability to enable digital identity from the private sector. We want to be the place where that occurs first. We want to be leading in that private sector, but how can we enable that from a public perspective? There were a few ways that we came up with that could be incorporated into a bill draft if we choose to, or maybe it's something that that we work on later. But those would include recognizing electronic credentialing, for example, educational credentialing, recognized through a digital identity, where your degrees, your high school diploma, any other education related piece of information about you can be included in your digital identity. And remember, this digital identity at that point is going to be something that you have control over. It's going to be your permissions that are involved, so that credential can get hung on to your digital identity, but that helps to provide some recognition. Education credentials, as I mentioned, are a key to that credentialing. Driver's licenses, we know that we're going to be spending money on new driver's license. We had testimony last time about how we could potentially work with YDOT to enable and ensure that digital identities are interacting appropriately with what YDOT does moving forward. And then we've had a lot of discussion about corporate records. So a digital identity is not necessarily restricted to a person, but we can have a corporate digital identity, and that can be interacting with the personal digital identity. And that might be part of legislation that we would potentially move forward. And then there are a number of engagement opportunities for sort of what is our killer app. There's engagement with the Department of Homeland Security project that they're working on it right now. We could try and partner with them. There are other foundations and entities around the country that have been working on digital identity. We could look for partnership. But one area that I'll ask Mr. Land, who I believe is on now somewhere nearby, to talk about and comment on is briefly, we understand, and Ms. Long has mentioned this before as well, that the KYC AML travel rule is going to lead to some interesting complexities that might be resolved through digital identity. And this might be a use case or something that we could enable through legislation for digital identity to help remedy the challenges that we'll observe through KYC AML travel rule in a way that would be meaningful to the financial technology sector that we've been working with. And then we had a lot of discussion about the privacy side of digital identity, which is a challenge. How much privacy do we want? What model do we want to use? How do we treat the digital identity and the data associated with it? Whether that's an ownership concept, property concept, whether there's intrinsic and sort of unalienable rights to some of your digital identity and that personhood. All have to be incorporated into a piece of legislation, and that's probably something that we want to at least nod to up front, what direction we're going to go there. But I mean, we could go as far as incorporating some of the language in the California Consumer Privacy Act, for example, where we go far down the path of protecting personal privacy through the digital identity. And then we discussed concepts about that might make us unique about providing strong civil protections against privacy intrusion or mismanagement of digital identity information. And then talked more broadly about certain applications where maybe if we're looking at the privacy side, we can look at specific instances, some of the things we looked through digital information privacy years ago, but with a digital identity component being brought to bear. I think I'll stop there and leave and see what else I've missed and leave it up to some of the other members of the committee to provide some comment. Representative Yin may have something to add, and if not, Senator Driscoll, or we can go to other members of the committee thereafter. But I'll stop there, and then we can go into discussion about what we want to do to proceed and get any additional direction or thoughts from the committee, look at public comment and everything else.
Okay, thank you, Senator Rothfuss. Representative Yin, I saw you unmuted there. You ready to jump in?
Sure, Mr.
Go ahead.
Chairman, thank you. I don't actually have a lot to add. I think Co-Chairman Rothfuss did a good job of summarizing the results of the committee. So I think it now comes to the full committee to wonder what comes next. So I look forward to listening if anyone wants to push something forward.
All right, thanks. Who else was on your committee? Senator Driscoll, you have any
Senator
comments?
Driscoll.
Senator Rothfuss covered it well.
And we had Joel, Mr. Reville.
Yeah, thank you, Mr. Chairman. I thought one other idea that is, I think, an application from this is to create Wyoming residency as a piece of this. The clarification around that for tax purposes, for purposes of access to some of Wyoming's more attractive laws, whether that be corporate or trust, et cetera. I think being able to trace back with some additional evidence that either person or LLC or corporation is a Wyoming resident would be an additional application from it. Thank you.
Thank you. And on that, Mr. Chairman, Joel, do you want to talk a little bit more about the nuances of that briefly and why that is something that we discussed and looked at? I think some of the deeper points provide good context for it.
Sure. Mr. Chairman, Senator Rothfuss, I guess one nuance that I think you're referring to is that the state of Wyoming doesn't provide any sort of test of whether an individual is a resident. So what happens if someone is looking to change residency or perhaps domicile assets or a trust in Wyoming is that because there is no test in Wyoming, it falls back on the state from which they're looking to abandon residency. And that can be a moving target. And is getting increasingly onerous. And as other states fall into more dire fiscal situations, I think that just increases. So to the extent that there could be some evidence provided by Wyoming when someone is seeking to establish residency here, again, either person or LLC or corporation, that could be helpful.
Perfect. Thank you. And, you know, on that point, the other jurisdictions provide that authentication. Not very many. Mr. Allen can talk a little bit about some of the what other jurisdictions do. Maybe when he provides some of his testimony to address that. But it's certainly not unprecedented. But I don't believe there is a digital identity provider as a state in this country. So we'd be leading. I believe, if we were to go down that pathway. And then, Mr. Chairman, I think Mr. Land has joined us, if I'm not mistaken. Yeah, he's on as well. If he could join, and Mr. Land, I don't know if you were here. I was suggesting a little bit of discussion on some of the things that we looked at when we met with regard to KYC AML travel rule. Ms. Long has raised that in the past, and it was one of the things that I think there's some possibility of us using our digital identity legislation as a means of easing some of the challenges and concerns that will be associated with the KYC AML travel rule, and wanted to see if you had anything that could provide a little more context there and maybe even describe the KYC AML travel rule to the committee so that we're more familiar with it.
Thank you, Mr. Chairman. Can you hear me okay?
Yep.
Yeah, there's a little bit of background noise, but it's not too bad.
All right. Yeah, sorry, I don't have video capabilities at the moment, Mr. Chairman. But I will say that, so the travel rule is kind of a global AML KYC concept that requires all financial transactions in funds that are above a certain amount. The sending financial institution has to send certain personally identifiable information to the receiving financial institution that's associated with the transaction. And the travel rule applies to digital asset transactions, but digital asset transactions by their very nature are disintermediated, so there's not always a need for an intermediary. And you can also have the situation where you would have an intermediary that's transacting with a non-intermediary. So, for example, a bank that's sending crypto to a person, we call it a non-custodial wallet. So there are all kinds of eccentricities and issues that need to be addressed to prove that crypto can fit into existing laws and legal structures. The industry is going to be releasing a white paper here shortly on kind of their solution to the travel rule, and I think there could potentially be opportunities for Wyoming to lead on this issue too. It's too early for me to say on the record. And I do think it's probably best for this committee to wait until the next meeting. Of course, it's obviously up to you guys in every way, but I think we'll have some more clarity on how the AML KYC issue is going to shake out, especially within regards to the travel rule here in a couple of weeks, and then we can see what opportunities there are. Thank you, Mr. Chairman.
Thank you, Chris. Appreciate it. And with that, Mr. Chairman, Mr. Christopher Allen was a member of the working group as well, and he has done a good bit of legwork on trying to put together a community that can help vet some of the ideas that we have for putting together a legal structure. And obviously, he's done a tremendous amount of work in the past on digital identity, and so I offer him an opportunity to share some additional thoughts, as well as we've got a preliminary draft concept of what a definition might look like that he can walk us through as well. So I'd invite him to share some of those thoughts, and then we can take a look at what that first draft of a definition of digital identity we might put in statute would be.
Thank you, Mr.
Okay,
Chairman.
Mr. Allen, go ahead.
Thank you. So I wanted to sort of preface my thoughts on, that we take a particular care that identity is not a singular, especially when we're speaking of digital identity. It really is a plural, because you have many different digital identities depending on who and how and what level of recognition and support you need. So, one of, I think, our principles needs to be that we want to enable a lot of different forms of this in ways that are safe for our constituents and allow for, the rule of law, but also, but safety is really important. So we want to be careful and not, for instance, I think the example we gave last time, you don't want your daughter necessarily to give all of her personal data when she goes into the bar about where she lives and, and her other identifiable information and assurance, et cetera. And that applies at all different kinds of levels. You don't want to, we do need to have identity assurance and verification and other different types of things for things like wills. And, we want notary for some types of things at the high level, but we don't want all of those things to go all the way down to the bottom with, in order to log into Twitter, I've got to give my my blood. I don't know. I'm exaggerating there, but I think the point is that we need to design things that allow for flexibility and no more private information, no more personal identifiable information than what is necessary for the business purpose, for the government purpose that is necessary. So there isn't going to be one Wyoming identity, I don't believe. You might have an identity that's associated with your right as a commercial registered agent. That's one of the first digital identities I'd like to see Wyoming have. You would have a different one as a student of University of Wyoming and the various degrees that you have there, or through some trade school or whatever that is in Wyoming. So we really need to try to allow people to keep those separate and clear. So I have been reaching out to a number of legal scholars who are experts in this area. And some have now said, yes, we're really kind of excited about the opportunity to do this right and create a foundation. In particular, I had a long, hour-and-a-half discussion with Dr. Claire Sullivan. She's a visiting professor from Australia, but she's at Georgetown University, and she is a noted scholar on international digital identity, both from Australia, but also from European and GDPR and things of that nature. So she had a lot of interesting comments and thoughts on the draft that I had prepared. And we also have Daza Greenwood, who is at MIT and has been working more in the United States on digital identity and such for at least 6 or 7 years. And he's one of the people that wrote one of the papers about the risks of having all of this fall under property law. So I was really glad to hear that that he wants to be involved, and Scott David, who's at University of Washington, who's done a lot more stuff around fiduciary side of identity. We need to have parties that, hold our data, but they need to be thinking about it in ways that, have greater responsibility than maybe contract law has. And he has some interesting thoughts there. So I think we now have the right base group. I think we have sufficient kind of different perspectives on that we can get some really good things done. I do have a Google Doc that I've been sharing. Again, it was not written by a lawyer, it was written by me. But trying to use the best of what I've seen from different places. And I initially focused it on just being able to add or digital identity to last year's privacy and private key proposal that did not pass, and we believe should be, I think the last session you guys said that you wanted to move it forward. The basic idea is you have a private key. It is the thing that connects your real world to the virtual world. If it's abused, if it's not done properly, people can take over your digital identity. They can steal your coins, they can do other things, and there's no recourse. It can be used by to create wills and sign things and things of that nature. So private keys need some extra care. This bill, I think, addresses some of that extra care. But in the last year's draft, it was only for digital securities and virtual currency. And this would just simply add digital identity to it. But unfortunately, we've already, got good language for virtual currencies and digital security and other legislation in the great legislation that Wyoming has done in the last few years. We don't really have the equivalent in digital identity. So I made a proposal for one that maybe is a little bit too long for that particular small purpose. I mean, this is almost as long as the original bill was, but it's a solid foundation for things like privacy rights and for a variety of other things we might want to build on top of it in other bills. So I thought that was kind of a good place to start. I do have the link I can share. I'm not sure what the best way to do so is.
So Chris, for the public, why don't you share your screen and
Sure.
show that definition, and I will circulate. I'm going to email the committee. Is this open shared? Do you have it
Yes,
shared so
it
that
is
everyone?
shared for shared comment. It's shared and anybody can comment.
Gotcha. So I'm going to share it right now with the committee, but you go ahead and share your screen.
Sure. Let me just make sure I have the digital identity definition. There we go. Okay, so this is, starts with the, the terms from last year's act, which is no person shall be compelled to produce a private key. And I'm not going to talk about, why that's important, but I think we've had stuff about that before. But I've added, or digital identity as the baseline. And so that means we need to define digital identity. We've already identified private key, but then we needed to do so. And some of this may feel unnecessary, but this was again talking to some legal scholars to provide a good solid basis for other things. So literally we start with entity because we do have things that are that have digital identity that are not necessarily natural persons. So we have, of course, the identifiable natural person, but organization for purposes of things like the corporate registry and other stuff we have. But we also have a lot of digital things out there, whether or not it's our IoT devices or the alarm on our house, et cetera. Right now, those are kind of controlled, whether or not you paid for your Google Nest thermostat or the doorbell on your alarm with a little camera in it. Reality is that it's really owned by the company that gave you it, and you're just licensing it. It may be increasingly important that we also protect those as being under your control. But then we come to identity, which we really try to focus on what we call the functional identity definition. There's lots of other ways of talking about identity, but we're really only focused on that part, which is what we call functional identity, which basically is all the different ways that, an entity, one of those three above, recognizes, remembers, and responds to other people, right? I've met you before. I recognize your picture on the screen. Similar things happen in the digital world. And then, that, among other things, gives you a group affiliation. So for instance, I know that Senator Tara Nethercott is a member of this committee. So there's an element of group connection there. So we've got some other stuff. And then we just simply extend that into the digital world to say it's any information for realizing or managing an identity, but not, including but not limited to the collective aspect of all these characteristics, the set of behaviors that we have when we're using these characteristics, and the distinct personality that we have. And then in particular, this is where we start getting into ability to do it in other laws, information such as an identification number or other correlatable information that is used to establish, link, claim, authenticate, or prove an identity. So it's a pretty good baseline. We're not talking about property rights. We're talking about various aspects of things. The sources of where a lot of this came from, one was the International Bar Association, just did a fairly recently a report on digital identity principles out of mostly sort of from the European GDPR perspective. That was what I used as a baseline. The developer community has been, trying to really focus on this functional identity as a way to get through the morass of the philosophical, I think, therefore I am type versions of identity. And then, we try to address, when people talk about digital identity, they usually come from one of 5 models. And how do we talk through all the different models and ways people think about digital identity? So after talking with Claire and some other scholars on this, they like it. They say it has some real strengths over the Australian and GDPR kind of baseline. The California one doesn't even refer to digital identity. You have this great, everybody praises the California Privacy Act. It never refers to identity at all. When it, other than the fact that personal identifiable information. So she thinks this is good, stronger than that. She's wondering if we need to have one more statement, which is a personal digital identity, to sort of clarify that natural persons, are a special, an important different case. She says there's a lot of law around control to get around the property, own your data, instead to allow for things around, other approaches to it. She really likes the language of control, which I'm already using, but she has some good references there and wants to introduce more. And she really, feels like we may need to talk a little bit more about the concept of transactions that aren't property transactions. I mean, we have a transaction that's happening right now. I'm giving you information and, you're commenting on it and things of that nature. So we want to talk about these things that are transactions that aren't just property transactions. That's the baseline. Clearly there are subtleties in here, whether or not this is the right bill to put this into first, whether or not something else might be better spot the exact language of this, but at least it's a good base that's new, strong, takes a principled stand and, gives us a starting point.
Thank you, Mr. Land. And Mr. Chairman, just following on that. So this is a conceptual draft that we discussed a lot of the points in it. And I think the folks on the working group agreed that the first thing we needed to do, and if nothing else, the one thing that I'm confident we should have a piece of legislation that does in the upcoming session is this definition piece and getting the definition right. And again, it's nowhere out there in the country. This is another area where we have an opportunity to lead and shape and define. So we need to do it very well and bring in experts. And Mr. Allen has already started trying to assemble that team of experts to get the right people on board. And so we've already started to have some good input. But that in and of itself is, I think, a critical exercise. And it probably, in my view, would need to be a standalone bill that somehow maybe corrects for, or if we run the private keys bill separately, we would want to include digital identity. So we have to make sure those conform. But having a digital identity standalone piece of legislation that was recognized kind of as the seminal piece of legislation associated with digital identity in the country is the objective of the working group. With that, I think we're open to any questions and discussion. We've still got work ahead, obviously, but I like the direction that we're going.
Committee, Senator Dockstader.
Thank you, Mr. Chairman. Follow up to Chairman Rothfuss's comments as we do this. I mean, if we are breaking trail, we don't want a situation where we embarrass the state down the road. So do we, and I trust my two chairs who've tracked this longer than I have, you would have the right team to put that together?
Mr. Chairman, Senator Dockstader, Mr. Allen is one of the world leaders in this in terms of kind of the concept side and developing the international standards. And we're trying to assemble the folks that work on the legal side of it. I think that's what we don't quite have yet. So get the lawyers that have been working on this and trying to think through how the concepts associated with digital identity from the tech side interact with the governance side. And we're trying to put that team together. So I don't know if we have the team yet, Senator Dockstader, but our hope is that we'll have that team and that we'll be able to get everyone to kind of agree on an appropriate direction for it. And then recognizing that there have been, and I'll have Mr. Allen comment on this in a second, that other countries have gone down this path further than any jurisdiction in the United States. And so we need to be thoughtful of what others have done as well and maybe learn from those. But I see Senator Nethercott has a question.
Yes, Senator Nethercott.
Thank you, Mr. Chairman and Co-Chairman. I think what I heard in response to good Senator Dockstader's concern, and of which I have shared and have been resistant in the previous year on this topic. What I heard Chairman Rothfuss say that willing to go as far as a definition. And I think that that is the safest route to go on this topic. My concerns in the previous interim, really centered around the limitations of really the court's ability or the law's ability to access some of those applications associated with digital identity. And that's where my resistance or concern came in. As we continue to work through this issue, which I think is fundamentally important and consistent with all of our other work, more so than any of the other topics we've discussed yet today, I am comfortable with us establishing a definition, less comfortable with some of the limitations or applications of how that definition may or may not be used within the legal context. But that's my signal, in that I think we are in the right direction, and it is right to limit our understanding of what we're doing to providing that definition and stay away from providing legal limitations on how that definition may be utilized in a court system.
Representative Greer.
I won't be able to say this as eloquently as Senator Nethercott, but I agree with her. And I put it this way: I think we start with the definitions, and it's more of a seed bed, because we can get those there. And then as we develop the concepts of other legislation of how we get this to work into our everyday life, those definitions might need to be modified or added on to. But if we at least have them there as a guidance to move forward, I think they'll be helpful. One of the things, Mr. Allen, one of your comments of things we should look at, I think is very important, is a bifurcation, or however we want to do that, with respect to entities and then people. And, I act on behalf of entities as a person, but it is, there is a distinction there. And I think that needs to be a little further developed as we look at definitions and lay that out a little better.
Okay, Mr. Allen, did you have any follow-up?
Well, only that, so to give you some scope and scale, the entire nation of Canada is moving to a decentralized identity system. Netherlands and New Zealand are closely following it. Companies like IBM, Microsoft, et cetera, are actively engaging with these countries around legally enabled self-sovereign identity. There are hundreds of people and hundreds of millions of dollars, if not billions of dollars at stake in this area already. So like the functional identity thing, some of these different things are already happening there, and we're connected in and have the real opportunity to be a lead here, because California already had some digital identity-ish type stuff on the plans and books, but they didn't they didn't want to touch that when they did their privacy bill. GDPR was is 15-20 years in the making, and they all recognize that there were some things along the way where they had a foundation that wasn't ideal. So I think we're in a position, because there is, as far as I've been able to tell, there is nothing in Wyoming law around digital identity. The closest that it comes to is there's a mention of a digital identity of a stockholder, but then it doesn't define it. So I think we're really in a good spot where we can do some good things. We can do, be a real leader here, and we can get not just national recognition for our efforts, but potentially influence the world. So I don't think we want to run into the kind of stuff that China is doing and other places. We need to have an alternative that is that meets Wyoming standards and Wyoming culture. That's it.
Thank you. Senator Rothfuss, were you going to chime in there?
Mr. Chairman, thanks. I think I appreciate the comments and the feedback of the committee. I think that I'm glad to hear everyone's comfortable with trying to put forward a definition as that key first step. I think that's a good concept. One other question I do have for the committee, though, is, and we don't have to decide this now, but we've talked about the idea that it almost needs some sort of first killer app or application, or how we tie it to something that's being done to help us to not only work it through, but to enable it and to attract attention to it, and the reason why we're doing it, instead of it just being a thought exercise of, as Mr. Allen said, right, the I think therefore I am type of statute. Why are we doing it becomes a question. And we've had a few discussions of some early concepts. Mr. Reville mentioned the idea of linking it to state residency. We've talked about linking it into our, if we get the Secretary of State's office to work through the commercial filing, it's very reasonable to link it into that as well, or make sure that there's cross compatibility. And then Mr. Land mentioned the idea or discussed with us the KYC AML travel rule that we'll probably need to look at more later once we understand from this white paper what might be done. But I would like to ask the committee about thoughts on other potentially low-hanging fruit ideas of how we can engage this system without a substantial amount of risk. If anyone has any ideas on, well, hey, we should at least tie into this or that. And we've got forgot to mention the driver's license system upgrade as well. But any other ideas, what we can tie into, and maybe that's a separate bill, but it would be nice to be thinking those things through at the same time that we're working out the theory, that we're trying to be thinking through an implemented practice as well.
Yeah, go ahead, Mr. Allen.
Yeah, the main one I was going to mention, which other places are doing very early, is educational claims, which are everything from, your, ordinary, courses and graduation and things of that nature, but also includes like professional training and continuing education. If I don't know how many of you are bar members and have to have your continuing education credits to turn in every twice a year or every 2 years. But, that's something else that's kind of a low-hanging fruit, smaller group of people, not a lot of harm and damage there, and is, things where you do want to legitimately share. Yeah, I'm doing continuing education. So that's another area.
So
Thanks.
Representative Greer.
Yeah, so Mr. Chairman, and then Senator Rothfuss, Mr. Allen. So this is where I come back to, I need to, and if I need to understand this a little better as we develop definitions, at least 5 or 6 more people in the House are going to need some help. And so I look in the business world, I can have and designate an authorized agent to act on behalf of the business entity, okay? In the personal world, I can have my power of attorney act on my behalf. There are some things that I have to do personally. One is do my own CLE, my own voting, my own eye exam, and those things for the driver's license. How do we define that so it is workable within the definitions? And there are those categories. Because I could tell you right now that sharing a digital ID for a business entity with the people who are authorized within that entity is wonderful. Speeds things up. It'd be great. There are maybe some things personally that I would trust to my spouse or children or a good friend. But yet again, there are other things that are just me. And you've had these discussions. I've heard you talk about these things. how do we put together a definitional scheme that we can work with to accommodate? And those are just three I'm coming up with. I'm sure there's probably more.
Let's go to Mr. Allen on that one. He can address some of those concepts.
Yeah, so that's actually, you know, some of the subtext of this early part of the definition was to allow those things to be built on top. So there already is a concept and technology behind it around various kinds of both delegation, but also conservatorship and stewardship. And, you know, potentially fiduciary responsibility, you know, applies not just to money, but applies to things like health and things of that nature, to be able to allow those to be incorporated in this. I'm sure too many of us are dealing with elderly parents or very young children that, cannot represent themselves, even if they wish to. So we already know that this is a, part of the story and part of the answers that we need to be able to have, and have a pretty good, architecture for it. A lot of it is keeping it separate. I mean, I think that's the challenge from, my old legacy days when I did SSL, TLS and things of that nature. We had a tendency to bundle all these things together in the same way that your social security number somehow became you. It was never intended for that. The Social Security Department hates that it became that. We need to find ways to untangle these things so that each one is only used as appropriate and under the rules and authentication, authorization, identity assurance, et cetera, that is required for that particular thing. And I think we've got some pretty good answers in this area. And if anything, I think we're to the point now where really it's the legal side that is holding us back on some of this. So I think we're in a good position where we can, do the right thing, protect people. It may not be as much of a problem in Wyoming, but like Taiwan is really involved in some of this stuff right now because they're looking at, God forbid, in 10 years, they may be the next Hong Kong. They're concerned as a government creating any kind of digital identity stuff that, might be abused by the next generation of the government there. These are the kinds of things these people are thinking carefully about. And, we can do the same. We can be careful. And I agree with, and I think I've been quoted before, anything identity is a two-edged sword. I don't care if it's, self-sovereign identity or what China is doing. We do have to be careful with identity stuff. It can be abused. So, and is being abused currently. So we want to make that as safe as possible.
All right. Senator Rothfuss, any more?
Well, I'd see if there's any more discussion or any more questions, and then I guess I'll then talk about next steps if there aren't. But I want to make sure we've got everyone's questions and thoughts. Looks like we're okay. So, Mr. Chairman,
tell us what's next.
Mr. Chairman, we've still got more work to do, clearly, and this was the first report on it. But what I'm hearing is that everyone would be very comfortable with us trying to put together a definition with some context around it as a good first step for us to look at. Won't be at the next meeting. It would be at the following meeting, would be my suspicion, that we would have that and get that in the form of a preliminary bill draft and start looking at that, and then keep giving some thought to, all right, well, and then how can we implement that? What would the preliminary killer apps be that we would try and put in place? But I don't think the definition requires that we know those now. So that would be what I would take as the next step, to keep the working group together, expand it, bring in some legal expertise, get to the point where we have a definition that stands up to scrutiny, is well vetted, bring that to the committee as a bill draft, and then make decisions from that point. So that's what my suggestion would be, and I'd see if the rest of the committee was comfortable with that. I guess I'll say this: any objection to that path? All right, seeing none, that's what we'll do.
Go forth and make a definition. I think you're right though, Senator Rothfuss, on having something to wrap this around and tie it around a little more specifically so that it's not just an academic exercise. And I think I would say this is true of everything blockchain done and going forward, that this committee has done, the task force has done over the last several years. I'm seeing it and experiencing it now more than ever out in the community, as we, probably because we're in campaign season, but as we get out and we move around and we speak to our constituents about everything that this group has done over the years, and it's done a lot. I think there is a lot of question on where is the benefit from Wyoming? And of course, we all know where the benefit is, and we show them the jobs and we show them the people. And we just talked about custody banks, and so it's all there. But I think it's important that this committee continue that tradition that it has of really, it's not just passing a bill that's new and sexy and different, but we're moving the economy and growing the pie in Wyoming. And I think we ought to find a way to really harness it with this as well.
Yeah, Mr. Chairman, this is a really big deal, getting this right, digital identity. There's so much activity in this space. And one thing which I didn't mention, but probably should have, is, we've no doubt got public testimony coming up to discuss as well, but there's a lot of interest in partnering with Wyoming, because if we're a first mover on digital identity, from, you recall testimony from IBM. I've had follow-on conversations with IBM, and there are a diversity of possible areas in which they'd be interested in engaging with Wyoming on digital identity projects. Microsoft is very interested. We heard from Google last time. Microsoft, I believe, is going to be presenting next time we meet. So we know that there's a lot of interest because of our first mover status in working with us to get this right, to do a great job. And then from our perspective, it all comes down to building Wyoming, economic diversification, quality jobs, and trying to strengthen the state. So that's the angle that we'll continue, certainly as the working group and as the select committee, to advance things. So I appreciate the direction from the committee, and more to come.
Excellent. So public comment. I don't know, Kelly or David, if your list has been updated from mine. Looking at my list, we have some general comments, probably save those to the end. But we do have Mr. Scott Meyer under digital identity as well.
I think Scott and Dean are both here. I know Scott is.
Oh, is Dean?
I'm
Okay.
admitting him, but I see a Dean in the waiting room also, and I'm going to assume it's
Let's try it.
the correct Dean.
Here's Scott.
Yes, good.
Except you just admitted Scott Moeller.
I think I did. Didn't
We
I
want
admit
Scott
Scott?
Meyer.
There we go. No,
Maybe
Scott
we want
Mueller.
Scott Moeller too.
We want Scott. We want Scott Mueller on this.
Scott, okay. We want Scott Moeller. We want Scott Meyer, and we got Dean there. You see, you came through. Perfect.
I don't know if Scott Meyer is Scott Meyer testifying on this one.
He is listed under Wyoming Bankers Association.
All right,
Digital Identity Working Group.
perfect.
All right. Scott, you're unmuted. Let's go to you.
Okay, great.
Welcome.
Thank you, Chairman Olson, and thank you, Chairman Rothfuss. I want to say thanks to the Select Committee and for the opportunity to present. And my name is Scott Mueller, CEO of MShift. And I'd like to follow up specifically where we see the killer app, and that's commerce. because commerce can bring revenue to the state, and we see a real opportunity with self-sovereign digital identity within a commerce ecosystem. So my testimony today will be, in essence, a continuation of last month's discussion when we spoke to the Select Committee with the Merchants Advisory Group. You can see John Dreschny here. He's CEO of the Merchant Advisory Group. He's here with us today, representing MAG support of our initiative. And Dean Schaefer is here with me as well. He is chairman of the American World Money Founding Council. Today, we wanted to share with the committee and the Digital Identity Working Group in particular, our deployment of digital identity, and one set of schematics that we prepared that describe how Wyoming's digital driver's license can be incorporated into our ecosystem. About 10 days ago, we met with WYDOT leadership to explore the possibility of incorporating their DDL for the use of confirming identity of individuals within our ecosystem. And although their DDL is now in pilot phase, we see that the technology can scale, especially if this DDL has a strong use for commerce. Using it for commerce, there's real benefits for WYDOT. When a state issued DDL can be used as a base level identifier to enable commerce. When this scales, the DDL can be a true revenue generator for WYDOT with increased enrollments. And then increased transactions then functions as a revenue driver for the state through more sales tax receipts. So I'm going to bring up on the screen. Do I have the ability to?
You should, Scott. Yeah, let me know if you don't.
All right. Okay, there we go. So I'm going to bring up on the screen some of the flows that we were sharing, and I'm going to minimize my video so I'm not interrupting myself. These flows put some more details of the vision of identity that we've shared with the committee before last month. These slides will show how we can use the Wyoming DDL for the generation of the individual's master avatar and sub avatars within our system as the establishment of individuals' digital self-sovereign identity. And we also want to show the transactional and non-transactional flows in our ecosystem. And can people see these slides?
Yes, we're good. Yep, thank you.
Okay. Okay, would it help if I zoom in, or you guys see clearly?
I'm good.
Okay.
Any problems? I think we're good.
All right. Okay. Okay. So let me just walk through a couple of these flows, and then I want to give kind of an overview of our ecosystem. So this first flow is, so we're showing the establishment of your digital identity for use within the ecosystem. So this is creation of your master avatar. Under the assumption that the consumer already has a WYDOT digital driver's license. Okay, so what happens here is if the consumer has a DDL, they're opening up their certifier app, and that certifier app could be a merchant, could be a bank, credit union, trade association, university. So someone, it's an organization that already has responsibility for managing PII, and they're willing to vouch for the individual being who they say they are. Okay, so they're opening up that application. Then they are opening up their DDL through that application. So via an API, or they're opening up the WYDOT app. They are scanning at a merchant a code, a verifier code. So you can think about it similar to the WYDOT law enforcement, where it's literally just a 2D barcode. That's the electronic handshake between our app and the confirmation. From that point, what we have is then we have the consumer has the DDL verified data that can then be incorporated into the certifier database. It's not on the blockchain. Okay, and then we are able to create the master avatar. The second flow that we have here is if the consumer does not have a digital driver's license. What they're doing is they're opening up their certifier app. So again, they're opening up their certifier app. From that, we'd like to see if we can work with YDOT to incorporate an API so that we can create a digital driver's license sign up through that. From that, they can create their digital driver's license. If we're able to scale, we can have this with short messaging. So they can use email or however they get it going. But ultimately, we'd like to get this to be as instantaneous as possible to get that digital driver's license verified data into the app, and then the flows continue the same way. And the only difference in this flow from the flow that you see before is our intent is to, we want our ecosystem, the network, to pay the fees to YDOT for the creation of that app. Okay. This one is going to be a little bit more difficult to see. Dean, are you on mute, or you have the ability to talk as well? Because I'd like to see if I can.
Sure, I'm here.
Okay, great. So yeah, just give backup it or fill in if there's any issues that I need. So what you're seeing here is an overall flow of the in-app master avatar creation. And really the key here is what we're looking to do is segregate the data by design. So there's different components that are known in the ecosystem. So apologies, I'm getting my notes here. So there's one pair of public and private keys for each user, merchant, identity certifier, and CryptoFed in the system. So there's 8 keys in total. So these keys generate various combinations of encryption and decryption to ensure the data protection and separation for various use purposes and transmissions. So we separate by design. Our network does not, when you create the master avatar, the network does not know who the individual, the PII information of the individual. The network knows the avatar, the sub-avatars, and it knows the transactions within the system. Okay, but it doesn't know the specific data about the individual. That data is resident with the certifier as well as with the individual. The certifier doesn't know about the transaction. They know that a transaction occurred, but they don't know where that transaction occurred at. They just know that a transaction occurred, but they don't know the transaction amount. They just know that a transaction happened. So it's really separating the distinction between the individual having the knowledge of the data. The individual keeps their own data to themselves. So Dean, anything you want to say on that?
Yeah, I think just the only thing to add is that in that upper right-hand corner, you see that the hashed value of the ID type and the ID number, once signed by both the certifier and by the consumer, that becomes sort of the key piece of information that you know that you have a real ID that is signed by a certifier and has been requested by a consumer. And we see that as key to the system.
Thank you, Dean. Yeah. So there's multiple public keys and private keys within the system, and the key is to segregate the data and to ensure that the individual has full control of their own data, of what they're willing to share. Leading on Mr. Allen's comments, you don't want to share all your data all the time. So when we have an individual that creates their master avatar, that avatar isn't used for most transactions. What they're doing is they're creating a series of subset avatars, and those sub avatars are what is used in transaction activity. So we have the ability to create a vast multiplicity of avatars for different use cases and use scenarios. So and I often lead back to people are familiar with the over 21, under 21 perspective. But what if you want to share with the merchant your preferences? Okay, so this gives you the ability to share preferences with the merchant, because that is data that both you and the merchant wish to have. So it gives the individual the autonomy to share data which is relevant to them, relevant to the merchant for specific transactions. And this also can happen in a non-transaction capacity as well. So we see commerce as the leading indicator of what this can become. Our role is to be at a protocol level. We are the currency level and the digital identity level. But there is a whole series of applications that can be built on top of this. More details on this is demonstrating how the data creation, the hashed ID data creation, the real ID. So the digital driver's license is never shared on the blockchain. What happens is the data is kept within the certifier database off of the blockchain, but there has to be a signature encrypted both on the certifier level as well as by the individual in order for that data to be stored within the our database, which is also not on the blockchain. But then to be used on the blockchain, the master avatar has to communicate with the certifier to reveal that information, which is then matched with the information in the network database. Dean, any adds on that?
No, if you just jump back real quickly to the sub-avatars there, Scott.
To which part, this one?
No, it's the sub-avatars.
Okay.
Yep. So a key piece here, if you take a look at Scott's example of the wine avatar, you'll see that that avatar can have both certified and uncertified attributes associated with it. So in this case, the equal to or over the age of 21 attribute is certified, and Scott's preference in wines or his favorite wine and the price range of wines that he wants is not certified data, but there's still attributes that are part of that wine avatar that can be shared with a given merchant or multiple merchants, really any entity.
This slide gives more clarity on what is kept in the separate databases in order for that data to be shared online. And what you're seeing here is in the certifier database. Okay, it contains the digital driver's license information. It contains that personal information of the user, which is used to create a hashed version of the ID type for use online. In the network database, none of this data, this PII information is in the network. All the network has is it has information on that master avatar. Okay, so what we're doing is we are creating something online. Okay, and that master avatar then creates a whole series of subset avatars, which are used for transactional events. Okay, so those attributes are kept in the system. The certifier database also has a copy of the transactional activity. Okay, so I'm sorry, the network database has the transactional activity, and it also knows which avatar is with which certifier. So the certifier has the data. So if we have a bad actor occurring in the ecosystem, we're able to trace that bad actor, but we don't know who the bad actor is. We know who the certifier is that certifies that bad actor. Okay, so we are able to trace the activity in the system, but then that activity is then passed to the certifier. Yeah, Chairman Rothfuss, you have a question there? Okay.
Just drinking coffee. Go ahead, Scott.
Okay, gotcha. Okay. Okay. Here's another example of what can be done with the data that is resident within the American World Money database, so the network database. We enable a method of zero cost marketing and advertising on the blockchain which is broadcasting. So individuals have the ability to request rewards. Merchants have the ability to offer promotions. So you can do query and response. Okay, and we do not charge for query and response. And what that does is it effectively removes the need for digital advertising expenses. Okay, it's our intent is that for merchants have the ability to deliver the greatest rewards possible to consumers for any activity. Dean, any comment on that?
Just again, the data here that's being queried is off the blockchain, so it's not discoverable.
Right. Yeah, and that is our true intent here is to make sure that the individual has full control of their identity. They have the portability to move from one certifier to another certifier if they so choose. They have the ability to create the sub avatars as well as to remove the sub avatars if they so wish. But it's and to not reveal any personal information on the blockchain. The only data which is recorded on the blockchain is the from and to wallet address, the amount of stablecoin that was transferred, and a transaction code and receipt number. But of this data, all of it is masked. So what we're doing is we're using ring confidential transactions. I think that's something that Monero came up with, the concept. But the difference here is we're masking the transactions, but at the same time, we're able to trace back to the individual that generated the transaction in the first place. So it's creating a system where we have KYC, AML capabilities, okay, but we're doing that at the outset as people enter into the system. But people have full autonomy within the ecosystem for their transactional and their non-transactional activity. It's only when there is bad actors would that trigger an event where we have to trace. And this is let me back up a little bit. This slide talks about non-purchasing transactions on the blockchain. Okay, and I think this is a real key component. What is a non-purchase transaction? Any activity, writing a review, a social media post, a communication between one person to another. Those are non-transactional activities on the blockchain. And what we see is while commerce is a primary use case, it won't be the only use case. Okay, this gives the ability for a whole series of application layers to be developed on top of the underlying protocol of commerce and self-sovereign digital identity, of currency and self-sovereign digital identity. Dean, anything you want to add?
Nope, you did a good job.
Okay, cool. Yeah. And final slide I have here. This is Dean. You want to walk through this flow?
Sure, I can give it a shot. So this is describing how the CryptoFed, so the CryptoFed is the governing body of the AWM system, how it manages keys. So the CryptoFed has the ability to, Scott, can you make it just a little bit bigger for me?
Oh, sure.
Right, so the CryptoFed has keys for the wallet management. In addition to that, it has the AWM EID is essentially the hashed value of the real ID information. So it has the keys via a password to access those on behalf of the master avatar. So for example, in the case that a password reset needs to occur, they have the ability to do that. And Scott, if you'll scroll down just a bit.
Yeah, so account recovery, that type of issue.
Yep. So the master avatar wallet management database has the AWM EID, the password, the wallet name, the master wallet. And if the AWM EID matches, they're able to effectively unlock that wallet and allow for management of that individual's account.
Yeah, as we're creating the system, we are considering whether we can give the individual to have full autonomy of their wallet and not keep a key with the crypto Fed, or do we make it so that there's always the opportunity for account recovery? This comes up not just when people lose their wallet, but what if someone passes away? How is their family able to access their assets? Those type of issues. So you have to have a methodology by which people can come back in if they so choose. But if an individual chooses not to engage in the system, they could have full control of their own. Yeah. So that's my slide. So questions, Chairman Rothfuss? Oh, sorry, I don't. Yeah, I don't get.
There you go. Y'all, Scott, you just go ahead there. Take right on over. I'm just kidding. Yeah.
I bet.
Senator Rothfuss.
Thank you, Mr. Chairman. First of all, Scott, welcome, and John and Dean, we appreciate you joining us, and I know how important digital identity is to the work on AWM and MShift's work. So we're really excited to have you involved. And the question I have is again, most of what you're working on here, we enabled through the legislation over the past few years. But as we're getting into the nuance of how AWM works and getting into the digital identity, it would be useful for us to know what you need from us on the digital identity side to either further enable this. And it sounds like one concept is the killer app or the first app. It might not be the killer app. The first app that you're interested in is strong digital identity through the digital driver's license with YDOT. I can see that being obviously enabling for you. But when we get to the governance side and the framework that we've talked about before in other contexts, is there anything that you all want us to be really thinking about as we're putting forward maybe draft 1.0 of digital identity legislation that you would appreciate if we got right to enable your work? And I think everybody on the committee understands that this is a technology that's being rolled out in Wyoming because of the work we've done in the past, and we want to make sure that we keep that framework and development environment robust as it has been for you. So, any thoughts on what we should be looking at?
Yeah, I think, and Dean, you can follow in after I think you're on the right path. I deeply appreciate the opportunity to be engaged in the process. I do think that as Mr. Allen has put forth many times, the sovereignty of the individual is key. I think that we have to consider digital identity to be an inherent and unalienable right of the individual. So the individual should have the opportunity to share components of their digital identity. Okay, but when they consider who owns the digital identity, the ownership needs to be the individual. So that to me is key. Our digital identity definition is pretty simple. We can use a digital version of a physical government issued identity, which is what we're doing with YDOT. But ultimately, it's the creation of an individual's character online. Okay, and the individual should have the full freedom to modify that and share components of their identity as they so choose. Dean, anything you'd like to add to that?
No, I would just mention that in the last testimony by MShift and the MAG, we submitted a couple of documents that outlined several of the key pillars that we see that need to underlie digital identity, things like self-sovereignty, ubiquity of use, that sort of thing. So we would ask that as you consider legislation moving forward, you consider those two papers as well.
Great. Thanks. And John, I don't know if you have anything to add also, or
No, I think they've done a good job identifying it. I think the hard part on some of the, I was listening to your previous session and you guys were talking about some of the good work that was done in California. Part of what has to be done too is to think through what are the negative consequences. Well, that California law did a great job in moving privacy forward. Sometimes it wasn't done with the commerce group engaged with it. And so practices like preventing fraud and what then became changed that that some people lost to prevent fraud became a problem, right? And they went back and fixed the legislation. But those are the things, like, as long as you guys are doing a great job at keeping everybody in the conversation. And I think that's going to be the key to get to something that really works for your constituents so that they get something that is powerful and they have control over and can be used to help protect them long term.
great. Thanks, John.
Okay. Committee, any other, now's your chance to ask Scott and Dean and John if you have any questions. You guys get off pretty easy, actually.
Well, Mr.
All right.
Chairman, I'll just say, and I know they will stay engaged, but as we work on the drafting and start moving this forward, this is what we want to be able to enable, and we want to make sure that the statutes we put forward strengthen the ability to do the types of digital identity-based transactions, the self-sovereign identity-based transactions that will be operating under your system. So, stay with us, and I know you will.
Oh,
Yeah, I was just going to note, Mr. Chairman, as well as I follow through your presentation here. What I think about is My Colorado. I don't know what it's called, but My Colorado app or My Colorado ID, whatever it is. But they've got, they've got a public app, and on your app, the main function is your driver's license. But it seems to be that the main thought behind the app is to be able to do more of these, engage in different transactions. I don't know if you guys have looked at that at all. I don't know how sophisticated any of that is, or if it's really just an app that has a digitized version of an ID on it, which is far different than what you're envisioning. But seeing something very similar, at least on our model here, and I really think it's the most practical way that we use it every day, is going to be in the form of our driver's license, our ID. And as you transition that, whether you're signing something or purchasing wine or whatever, your driver's license is a component of all of that. And I just think that that's probably one of the easiest starting points for all of this.
Yes, the key is your data doesn't need to be revealed. Okay, your data just needs to be affirmed that yes, you are who you say you are, and that you have the ability to engage in a transaction. At a base level, all the merchant knows here is that the individual has the ability to engage in the transaction. Okay, and okay, give an example at the bar. Okay, they just need to know you're above 21. Okay. But it's to your benefit as well as to the merchant's benefit. Let's say I'm at a local bar and I want them to know that I really prefer amber ales, right? Okay, and they want to give me a discount and they want to see me come back again. So I'm sharing that data. I don't even have to share my name. I don't have to share any other detail about myself other than that component. So the system enables that type of interaction.
Yeah, and I think you could back it up to, I don't know if you were in our conversations earlier when we were talking about electronic wills, but we broke into notaries. I think a lot about this. A good notary who follows the rules asks to see an identification before they witness a signature. And same concept there, but even broader, because my daughter may be handing her ID to somebody to sign a random document, and all they need to do is verify that she is who she is. But now that guy has her address. And so you take that into a very broad area where maybe you're not frequenting the bar, but you're just handing your ID to someone to sign a document, and now they have everything they need to know to go out and stalk you. So yeah, I think it's tremendously, that ID fitting so tightly into this concept, and being able to own your identity and protect it. Huge.
Great.
All right, guys. Well, thanks. I'm sure we'll be seeing a lot of each other. And Senator Rothfuss, you're moving the group forward. You've got some ideas of what you're doing. So perfect.
Yeah, we want to be deeply engaged. So we'll get our hands in the hamburger on this one.
Perfect. Thank you.
All right.
And Chairman Olson, let's see. I don't know if we have anyone else. We do separately on this topic, don't we?
We do.
Yeah.
We have,
Yep.
well, we got the Bankers
Yep.
Association. Scott, if you're still with us.
Yep.
Well, other Scott. Now we want Scott Meyer.
There we
Yep.
go.
There's our bankers.
Good afternoon, Mr. Chairman, members of the committee. As you might imagine, this is a very interesting and a very important topic for my members. At this time, though, I don't really have any questions or comments. I just wanted to see what was going on and see if there was anything I could add, but I can't at this time.
You know, Scott, I feel neglected, because when Representative Lindholm was chairman of this committee, anytime he just simply uttered a word, the bankers wanted to participate, but I guess he made them a lot more nervous than Senator Rothfuss and I do. I'm not sure what that's about.
Well, Mr. Chairman, I don't think that we're nervous at all, but when there is something important to say, then I'll make sure I say it.
Great. Well, Scott, thanks. We appreciate it. And anytime you have a comment, just let us know. We'll bring you in.
Thank you.
Mr. Chairman, I think we can bring in, if we're done with that topic, although we can certainly open it up to committee discussion. But I think Mr. Land is available to rejoin, and we can look at the KYC AML portability next, which we tabled. When we're done with this discussion, I'll make sure he is aware we're going to switch to that. I think he's in the waiting room. Yeah, he is.
I just brought him in.
Excellent. But I don't mean to prematurely end that conversation if others have anything to say.
Anyone have anything? I know you kind of asked that before and everyone just gave you the nod there, Senator.
Yep.
Okay.
I think that's where we're at.
All right. Chris Land, can you hear us? Back on the, no, we can't hear you.
You're on mute, Chris.
Sorry about that. Yeah, I can hear you great, Mr. Chairman. Thank you.
I guess I don't know if you got the message, but chairman of the working group, chairman, Representative Lindholm, said that maybe you would be the best to speak to us on this working group of KYC AML portability.
Yeah, Mr. Chairman, I can give you some brief comments. Thank you, Mr. Chairman. So we're kind of in the initial stages of the working group. We haven't been able to figure out a time to meet that comports with everyone's schedules, but I will tell you that we are looking at, trying to figure out ways that we can use BSA AML and some opportunities that the feds have encouraged in the past for shared services to kind of alleviate the BSA AML KYC burden on our community banks in particular. There's been some guidance issued by the federal banking agencies on encouraging smaller community banks to band together to kind of share the compliance burden, because BSA AML is a really important part of federal law that every bank in the U.S. and trust company, every financial institution has to comply with. But at the same time, BSA AML disproportionately impacts smaller community banks because of the sheer volume that the Wells Fargos of the world can resources towards their compliance program. So we're kind of discussing potential options for shared services between our community banks in Wyoming, and I don't really want to give out any more details than that at this point. We'll wait until the concept's a little more fully fleshed out, but there are some interesting things that we can do as far as streamlining BSA AML KYC. With that, Mr. Chairman,
I'll stand for any questions.
Thank you for that update. Representative Lindholm.
Thank you, Mr. Chairman. Mr. Land and the Wyoming Division of Banking went a different direction than I think everybody else on the working group. I can't speak for Senator Nethercott, but I'm pretty sure I'm speaking for her right now because her video's off. That we wanted to just completely violate the BSA and completely throw.
No, you don't.
Out the window. I'm just teasing. The reality is, and just something I wanted to add on to Mr. Land's testimony that I think is just very telling about how important this topic is that as soon as the PPP program came out and banks were tasked as the ones to handle that via SBA, the bigger banks in the United States were asking for relief from the BSA because it was just insanely impossible to try to set up all of these new accounts as quick as possible. The task that the government gave them. So they went to the government and they're like, hey, your regulations are stupid in this regard when we got to act fast. And so this goes hand in glove with many of the situations that we saw during this whole coronavirus pandemic where rules and regulations were suspended because they were kind of impossible to work around during COVID-19. Now, mind you, these are rules and regulations that were put in for the purpose of safety. And yet when it comes down to a safety issue, poof, they need to go away. So this is one of those situations I think everybody hopes that Congress will take action on. But we all know the sad reality that they're probably not going to. And so that's why it's so important that, and why I'm so appreciative of Mr. Land and the Wyoming Division of Banking, the Wyoming Banking Association, all those guys in regards to figuring this out. Because if we can figure it out and be the first ones through the door, I think that's bigger than what we've done thus far on anything else.
Mr. Chairman?
Yeah, go ahead.
And Mr. Land, as far as what's allowable with the new guidance, which banks would be able to work together? Would it just be state chartered banks, or would there be an ability to work together with federally chartered banks in terms of possible cooperation in the state?
Chris?
Thank you, Mr. Chairman. Senator Rothfuss. That would be up to the OCC on the part of the national chartered banks, and we would have to also importantly loop in the FDIC and the Fed too. But I will say that when that guidance was issued a couple of years ago, they all signed on to it. And so that's their existing policy position. It's just like everything, the devil's in the details. So we just kind of like the SPDI and what we did with digital assets, there could be a needle to be threaded that fully complies with the BSA, but at the same time it brings some common sense solutions to reducing the burden for some of our community banks.
And Mr. Chairman, a follow-up on that. Has any other state actually done anything along these lines to try and provide that flexibility?
Not to my knowledge, Mr. Chairman.
Okay. So again, Mr. Chairman, this is one of those areas where we can lead, and I think that's what the working group was really looking for, was something to allow us to separate ourselves from what others have done and provide some financial technology leadership. So good work, working group.
Ms. Long, you want to chime in?
Sure. Question for Mr. Land. There does seem to be some confusion out there about whether these KYC rules apply to non-banks as well, including for digital asset companies. Can you share, for the benefit of the public record, what those rules are and how that works?
Mr. Chairman, thank you, Ms. Long, for the question. The BSA and the attendant KYC and AML requirements apply to most financial institutions. So there are tons of non-bank financial institutions out there including money transmitters, trust companies, heck, even mortgage companies, have certain BSA AML requirements. So it's the breadth and reach is it's pretty much every entry point that someone could use to potentially launder money through the U.S. financial system is the reach of the BSA.
Yeah,
that includes crypto companies too. So.
Yeah, just as a follow-up, more a comment, because I obviously knew the answer to that. It was a leading question, but I think it's an important one. That it's not just the banks dealing with this Bank Secrecy Act. It's a bit of a misnomer, and what it means is that basically our own government is forcing the collection of this data by tens of thousands of companies, and there are going to be weak links in that chain. And it's a huge part of the reason why we have the amount of hacking and identity theft that we do. It's because of the magnitude of the Bank Secrecy Act requirements. Now, there's not, and because basically every financial institution has to share that information with each other. The travel rule requires that they share the identity information with each other. And so you've got a lot of data in motion, and data in motion is not as secure as data at rest. And it's just data's moving around the internet, personally identifiable data is moving around the internet all the time, every day. This is why we get hacked as often as we do. But there is, it's a big reason why we get hacked as often as we do, because the government created these data honeypots by forcing this into the financial industry. And then moreover, there's another challenge, which is that because this data is deemed to be voluntarily given to third parties under the third party doctrine that was defined by the Supreme Court, the government doesn't have to go get a warrant in order to get all that information. So the government already knows every single financial transaction that all of us already do, and they don't have to get a warrant to go get that information. So, and the problem is this is a federal law, and there's not much a state can do to protect the identity of Wyomingites. But I guess maybe it's probably worth, I don't know the answer to this question, it's probably worth kicking it back over to Mr. Land to ask, what, if anything, can a state do?
Thank you, Mr. Chairman. Ms. Long, first point about data security, I think that's absolutely, you're right on target. And anything we can do to assist, our financial institutions, banks, and community banks especially, with IT resilience and being able to provide their customers with better data security is a win. And hopefully, whatever if anything emerges from this committee in the form of a legislative proposal, hopefully that's a key component, is giving them stronger IT framework. On the second piece, federal law is federal law, and short of the Supreme Court reconsidering the third party doctrine, which I do think there are at least a couple votes on the Supreme Court for reconsidering the third party doctrine, maybe, but short of the Supreme Court reconsidering that doctrine, federal law is federal law, and you have to comply with it.
Perfect. Well, Ms. Long, I really appreciated the fifth law of Newton's fifth law of nature there, when a data at motion is less secure than data at rest.
That's quite good.
It's good. It's a good one. Mr. Allen.
You're on mute still, Christopher.
Yeah, I had a quick question for Chris Land, if you don't mind, Chairman.
Yeah, go ahead.
The travel rule has been, was really intended for financial institutions. But there have been some interpretations and also some international things of, anytime you're directly transferring, any monetary instrument, currency, gold, cash, Bitcoin, or whatever, and you're not going through a bank, you are now responsible for it as a business, which means that, if you're taking the proceeds from, cattle coin, or whatever Ogden's token is, and then buying feed from someplace that you might have to you might have the travel rule be applicable to you, even though you're not a financial institution. Have you heard anything more about that, or any thoughts on that?
Go ahead, Chris.
Is that a question from you, Mr. Chairman, as a legislator?
Sure.
Would someone want to ask that question? Okay, all right. Just want to make sure we're following the rules of decorum.
Chris, I love how you always keep us
Yeah.
keep us on task.
Okay, sorry. So the Financial Action Task Force is a consortium of a lot of government regulators from a bunch of countries. And they're the people who, issue guidance and issue the policy nuts and bolts that eventually become the travel rule and when it's translated into US law. So strictly speaking, whatever the Financial Action Task Force puts out, it's definitely persuasive authority, but it's not binding authority for the lawyers on the committee. The only binding authority on the travel rule is that which, FinCEN adopts in rule in the US. So I'm not really aware of that interpretation, but to the extent that it's not in US law, and I'm quite sure it isn't, because it only applies to financial intermediaries, but to the extent it's not in US law, it's not binding.
Thank you.
Senator Rothfuss, anything else here?
No, Mr. Chairman, I think that I'd like to hear more about what's possible. I guess the question is, do we want them between now and we probably won't hear from them at the next meeting unless they've got some update for us. But for the September meeting, whether we want them to start working on a bill draft to provide an allowance, or if we want to hear back from them before then related to a bill draft. So I guess I would ask members of the committee if we want to expect them to work that bill draft up, or if we want to get back and revisit in September 1st.
Chairman Lindholm, what are you gonna, between now and September, what are you gonna have Chris Land draft?
What am I gonna, oh, sorry, Mr. Chairman, I spoke out of turn.
Mr. Chairman, through the subgroup, I think it would be handy to have a sit down with Mr. Land again and kind of go over what direction this would look like. See if Mr. Land is willing to propose anything that's kind of up to our par of crazy. And if not, then
It's not that crazy.
Yeah, we'll make it our own brand of crazy.
Mr. Chairman.
Yeah.
Thank you, Mr. Chairman. This is at the very conceptual stage. Albert and I haven't even gone through it completely yet, and we certainly need to loop in the Bankers Association and stuff too.
Yeah.
I'm not sure it's that good of an idea. So it's early days.
Well, Mr. Chairman, one other concept that we've been kicking around for a while is the idea also of a data trust concept. Again, we've talked about this for several years, which would be an organization that would have some sort of a higher level scrutiny or higher level capacity to hold data and to act as that data repository. This may or may not be a good idea, but I guess as you're thinking about what to potentially do for this service organization, maybe there's room to create an organization that could end up kind of being both things. If you're going to have a heightened scrutiny for data, maybe to make that a lucrative endeavor or a worthwhile endeavor, we'd look to some of the models of what other countries have done with a data repository or a data trust or whatever the heck we want to call it. And Mr. Land, if you have any preliminary thoughts on that, we've talked about the data trust concepts before. These aren't perfectly related, but there might be something there. And if you have anything to share now, otherwise you can just work with the working group on it.
Mr. Chairman, Chairman Rothfuss, Albert's asked me to, make the point that if we're going to proceed with the data trust concept, we probably should look at creating the Wyoming Data Protection Authority, a new regulator or something like that, or at least, more resources or something. But as far as preliminary thoughts, I think we'll need to get the members of the, I don't want to say too many details because I'm not even sure it's an idea yet.
Well, as far as the Wyoming Data Protection Authority, Mr. Chairman, again, if it's a fee-based system that pays for itself, I don't see why we would resist that, much like the Banking Commission. If there's enough business interest out there that they want to pay licensing fees and get themselves regulated and audited to a certain standard and pay the associating auditing fees, that's good for business in the state. And I think we would want to encourage that. But again, we struggled with that in the past, getting it to the point where it would work as we wanted it to. So keep that in mind.
I see no better person than Representative Chairman Lindholm to be in charge of figuring out whether the trust data entity is best for Wyoming or not, considering his love for trusts as holders of data.
Mr. Chairman, I came in the legislature to legalize raw milk and sell guns. Just a little outside of my parameters. I'll give her a try.
All right. Very good. Well, and you've done all of that really well, Representative Lindholm, in terms of legalizing raw milk. So,
no, Mr. Chairman, I'm out of things to.
Yeah.
I mean, that's complete. So we gotta.
He's done.
Keep him busy.
I don't know if we have any public comment on this. I'm not sure whether the banking folks would want to weigh in. Maybe not at this time, but we should probably close this topic up and see if there is any public comment.
Okay. I don't see any additional. I mean, we have who I assume to be Bob Cornish hanging out in the waiting room, but I don't know what do you know what he's commenting on, or is he just doing general comments?
He's got public comment at the end, Mr. Chairman. I don't know if he was scheduled to weigh in on anything else.
Mr. Chairman, is the Wyoming Banking Association in the lobby? I'd really like to hear from them in this regard.
Let's see.
We could probably, they're probably watching.
I think so. Well, they're not in the waiting room, but I know that Mr. Meyer's been out there. He's listed this as a topic he'd like to comment on.
Mr. Meyer, are you out there? If so, please join.
Come on in.
Well, we can catch him at the end as well then. Final public comment. All right. Well, let's roll along to Decentralized Autonomous Organization Working Group, Mr. Chairman.
Okay. That sounds good. We have Mr. Allen in here. We should have Aaron as well. Mr. Allen, I know you were coordinating some with Aaron. He didn't give us any indication that he wasn't going to be here.
Yeah, I think there may be a scheduling. I think we're maybe ahead of the official time.
Oh, we are ahead of official time, aren't we? What time is this supposed to be at? Let's see.
4 o'clock. So now they're an hour before we hit.
Let's take a 15-minute break. Let's call them up.
Okay, let's do that. All right, so we will take a 15-minute break. Hey, Mr. Allen, you have Aaron's phone number?
I will call.
All I have is email, so will you give him a call, please?
Will do.
All right, 15-minute break. We'll be back at 3:10.
Okay, bye.
Please mute your video and your sound.
So Aaron is available. He's in the
Yep,
waiting.
I just let him, actually just brought him into the room. So hi, Aaron. We're getting ready to start back up here in just
Okay, great.
a few, and I'll do a little introduction and then I'll turn it over to the two of you, Chris and Aaron, to further the discussion. Aaron, we probably threw you off because as a governmental body, we were actually on time, ahead of time.
I know.
That seems unusual.
I was actually in the waiting room when you're like, "Where's Aaron?" And I was like, "Please let me in." So, I tried to be punctual, but I did tune into a lot of the earlier sessions. It's been really fantastic to listen to and as an observer. And thanks to everybody for the opportunity to present today. It's truly an honor.
Appreciate it. Okay, it looks like we're live. And I know that Representative Lindholm had to leave. He had another commitment that he has to get to, serving the good people of House District Number 1, as he often does. And looks like Representative Greer, we might be waiting for a return. But Representative Yin is back. So we got Senator Dockstader. Wow, the Senate's all here and the House is almost here. All right. Well, we'll assume that Representative Greer is here. He's gonna probably tune back in and we'll get started. Senator, Co-Chairman, if you're okay with that. Yep, you were muted, Chris.
Sounds good, Mr. Co-Chairman. Let's roll.
Okay. All right. So next on our agenda, ladies and gentlemen, is our Centralized Autonomous Organization Working Group, our DAOs. And I'm the chairman of that. And our group consists of Mr. Kaufman, who I think also had an engagement he may have told us about later this afternoon. So we'll see if he makes it back in. Senator Dockstader is in that group. Mr. Allen, Aaron Wright, and we'll introduce you guys a little more further on, but I just wanted to give everyone a heads up on who's working on this. So I'm going to do a little bit of background for the committee, just to explain where we're at and the steps that we've started to go through. And then what I'm going to do is turn over this presentation to Mr. Wright and Mr. Allen. Mr. Wright you are a professor of law, and this happens to be an area that Mr. Wright has spent a considerable amount of time on, not just in an academic sense, but has a good feel inside of the industry. I met with Mr. Wright and we discussed that if you compare this to a year ago, when the topic was first surfacing in front of the blockchain task force, there wasn't a whole lot of industry kind of chomping, wanting to see something move. But now Mr. Wright tells me that there's at least 10, groups out there, organizations out there that are at least interested in DAOs. So there's movement, which is why it's really springing back in front of us. For the committee members that are new to the committee, just a little bit of background on what this is. In essence, and the first and great DAO is really, honestly, without having a legal recognition as such, is Bitcoin. And so it's a decentralized organization. That's what it is. And so what we're talking about is taking that concept and applying to it legal existence. And this group met and we started to wrestle through some of the concepts. I'll tell you up front, and we'll get more into this, but up front, this committee is going to ultimately have a policy choice if we move forward with further exploring this topic, the policy choice that's going to be in front of you first is whether or not you define a whole separate legal entity, which is a route. And another route is to build upon existing law, whether that's limited liability company laws or partnership laws or whatever they might be. Build upon the laws that exist and not necessarily create a separate organization. Because that really brings you to policy choice number 2 that we started to wrestle with, which is, how much anonymity does this organization or this concept of an organization, how much is it entitled to? What should we give it as a policy choice? And what type of liability or limitations on liability should it enjoy? And so all of that springs off of, but it also centers off of that first policy question of, maybe we don't have to define so much of that if it exists on top of existing entity law. And of course, Mr. Wright will get more in detail on that. We had some conversations about digital RAs. That's come up actually throughout the day. Registered agents have come up, and so I'm sure we'll continue to discuss how that really fits in. Other discussions that we had centered around that, maybe it's not even so much as creating a legal organization, but it's actually our job may be to clarify certain law, possibly just existing law, whether that's in limited liability company law, clarifying, for example, when an interest or a member's interest is personal property versus maybe a security interest. And that's really where we start to move into the realm of where the DAO becomes relevant, is where it intersects with securities law and may or may not be those interests become highly fluid, highly exchangeable. And so beyond the anonymity question, there's a question of, is it, is that interest treated as a security or is it being treated as a traditional membership interest? And those are some of the things that we started to wrestle with. So where we're at is we're very similar, I guess, to the other working groups, that we are literally in the beginning stages of conversation. And today, Mr. Wright and Mr. Allen will present to you more in depth, because what we'd like to do, of course, is engage the committee, but what we'd really also like to do is engage industry and begin to get some greater input than what our group can provide, because these policy questions are pretty significant. And I think that's where the conversation will hopefully begin once we start our presentation, and hopefully it ends up somewhere great. So with that, Mr. Wright, I'll go ahead and turn over to you. I don't know, last time we had spoke, we were going to have a presentation. Do we have something to share screen wise? I don't know if that's Mr. Allen on your screen or on Mr. Wright's screen, but either one of you should have access to that.
Okay. Thanks so much, Chairman Olson, and thank you, Chairman Rothfuss. We really appreciate the opportunity to present to this committee and to outline some recent developments with DAOs or decentralized autonomous organizations. As Chairman Olson mentioned several seconds ago, we do have a presentation, so I'm going to share my screen, and then we can dive in and hit some of those topics and points that Chairman Olson graciously set forth before. Give me 1 second. All right, I just need to present. And I guess just in terms of, just to give some background, and this may be the academic in me, so I apologize, and I know it's getting late in the day, so indulge me for a second. But there really does seem to be a trend where each era of innovation not only leads to new technology, but it actually leads to new innovations in ways to coordinate human activity. The age of exploration really brought to bear chartered corporations. The industrial era, particularly in the US, heralded the birth of the joint stock company. The railroad boom created preferred shares, which is the primary way in which venture capital works today. And over the past 50 years, oil shocks and the growth in global finance has fueled the creation of limited liability companies, or at least expansion. And there's an argument, and it is an argument, but it seems to have one with a decent probability of success, is that blockchain technology and kind of the expansion of the next generation of the internet will be accompanied by a new organizational structure, and that structure is referred to by technologists as a DAO. And the reason that folks are excited about these structures is that blockchains at their core hold out the promise of changing the financial world, if not the entire internet, by fostering decentralized open networks and protocols. So the technologists across the US are hoping to build open networks where the software is freely available. Those networks are not necessarily owned or controlled by any one party, and they're used to facilitate one or more financial related transaction, but also hopefully over time, other related activity. And the emerging structure that's coming out of the woodwork to support these efforts are DAOs. And as Chairman Olson mentioned initially, Bitcoin in some sense, and this is debated, is a DAO. It helps coordinate activity. It's run entirely by software, and it's highly decentralized in nature. And that's what DAOs aim to do, right? They're aiming to help people organize their affairs privately using software, and they can potentially be accompanied by associated legal agreements, and we'll unpack that in a bit, to build organizations that are highly automated, so hyper efficient, a high degree of automation, and critically, they're also aiming to be internet native. And so this term DAO refers to a decentralized autonomous organization, but not surprisingly, that type of an organization is emerging in several different variations. So one variation is really a member-managed organization where group decisions are managed via blockchain-based voting. So hyper-participatory organizations where people use this underlying core blockchain-based architecture to keep track of group decision-making. And then based on that group decision-making, either allocate capital or take some sort of other action based on that. So very democratic in nature and very efficient in terms of being able to coordinate a whole bunch of different people regardless of where they're located. The second one is more in the vein of Bitcoin, which is a software managed organization where groups are coordinating their activity via an algorithm. So there's some early examples of that. It's not yet fully manifesting, but something that may emerge over the long run. At least in my mind, Wyoming led the last organizational revolution, right? As I'm sure the members of this committee know, in 1977, Wyoming was the first state to allow LLCs, paving the way for these entities to take over the corporate world. Now, today, at least by some estimates, over 2/3 of all companies formed are LLCs. And at least my interpretation of why Wyoming was so willing to adopt the LLC is that it really granted individuals and businesses a tremendous ability to express their personal autonomy by engaging in economic and social interactions that were primarily based on notions of freedom of contract, kind of this core concept that undergirds commercial activity in the US, which is our ability to enter into contracts with one another and to do so without much interference on the part of a government. And at the same time, it also maintained financial and commercial privacy, which left it really to individuals and businesses and other organizations to self-order their affairs. And I think that that's why we've seen LLCs really take the world by storm. And in many ways, other countries are still catching up to kind of emulate them. And obviously this committee also knows that Wyoming has led the way in the US with blockchain-specific legislation. Wyoming, according to some, is already becoming the Delaware of digital asset law and passing sensible regulation to recognize direct property rights, create a fintech sandbox, authorize the first true qualified custodian, but also it's paving the way for digital corporations with 3 laws passed in 2018 and 2019 that enable digital corporate records, corporate stocks being permitted to be recorded and settled on a blockchain, and exploring the implementation of a blockchain-based filing system to support corporate birth certificates and corporate proofs of good standing. But DAOs are a bit different than C corporations. While the Wyoming digital corporation statutes are forward-thinking, and I commend this committee and others who may have been part of this committee who passed those statutes, DAOs are operating with different assumptions than stock-based C corporations. So presumptively, they're not hierarchical in nature. So there's a presumption from the software developers that are putting this together that these organizations will have a flat hierarchy and be hyper participatory and ideally fully participatory in nature. So that means that there's not going to be a central board or a group of managers. Instead, members that participate in these DAOs will participate directly. Because these organizations rely on a blockchain, the transactional activity related to these organizations is highly transparent, at least in terms of knowing what's going on with the funds that are being used and the decisions that are being made to the extent that one of these organizations is relying on blockchain-based voting systems. And what's also emerging is a preference from the ecosystem for strong minority rights, which enable members that if they have provided capital, it provides them with the right to withdraw that capital at any point in time if it no longer suits the members' needs or expectations. So in the code itself, we have hyper-transparent organizations that are incredibly participatory and flat. And in the code itself, there are baked in strong minority right protections that enable people to maintain control over their capital. So in many ways, DAOs are more akin to member-managed LLCs. In a sense, many DAOs want their members to manage their affairs primarily using software as opposed to traditional contracts. So they're like member-managed LLCs, except at their core, it isn't a legal contract that the members are hoping to organize their affairs around. It's primarily around software, and software that technologists would refer to as a smart contract. And this software sets the expectations of the members and enables people, much like what we saw with LLCs, to order their affairs privately and to self-order what they want to do. They differ, though, from some LLCs in the sense that the vision for these entities is presumptively global in nature, right? Multi-jurisdictional off the bat, and hopefully scaling globally. And there's an opportunity, in my opinion, that Wyoming can really lead the way with DAOs. We're seeing in the ecosystem some early examples of DAOs being structured to be backed by LLCs with the hope of complying with US and federal law. These entities often are being referred to as LAOs, or limited liability autonomous organizations. And these LAOs aim to limit members' liability to creditors, but also give members the power to structure their affairs privately. So these are hybrid entities, partly backed by existing legal regimes, but operating primarily under the hood via software. What's also nice about these entities is that they're identifiable by state regulators and other officials. So instead of operating in the shadows, these organizations are trying to do what they can to organize these entities, but in a way that limits liability and also enables them to structure their affairs. And just some examples of how things are evolving. In kind of the first generation of DAOs, we saw things like blockchain-based protocols or various different organizations that were aiming to give grants, and some early decentralized applications or blockchain-based protocols that were hyper-participatory in nature. What's emerging in the marketplace now are DAOs that are supporting a whole bunch of different interesting use cases, from insurance pools to media and fashion production companies to investment funds, to things that may ultimately look a little bit more like a traditional business in some sort of sense. So this is kind of the ecosystem that folks are looking at and towards. And what's great is that Wyoming LLC laws largely accommodate DAOs, but there are improvements that could spur growth. DAOs that rely on an underlying LLC structure face certain struggles. They have to put together extensive operating agreements that modify many of the existing statutory default rules related to LLCs. And as Chairman Olson mentioned, it is sometimes unclear what the status of financial interest in a LAO is. I.e., is it a security or a commodity? I think one avenue forward, if of interest to the committee, would be exploring simplifying the default rules for DAOs. It's expensive for parties to put together an LLC operating agreement, costing businesses, tens, if not more, thousands of dollars to put together an operating agreement that varies from the default rules under Wyoming and other states' LLC laws, at least as interpreted by courts. For example, via contract, DAO members are often agreeing in an operating agreement to limit the need to have an express manager or owner, to modify some of the books and records requirements so that they're managed by blockchain and blockchain-based software. Some organizations do not want to have a high degree of fiduciary obligations between members, in the sense that they want these things to scale globally and have potentially a large number of people. So fiduciary obligations are being waived, although that's obviously a debatable question whether or not that's a good or bad thing, but it is permissible, at least under most LLC statutes and interpretive case law. And they're also hoping to preserve the privacy of DAO members through non-disclosure obligations or otherwise. So hoping to make sure that not all your information needs to be shared with the internet if you want to enter into one of these organizations. So one potential path forward would be to explore expressly permitting LLCs also to defer to software. So much like Wyoming's recent digital corporation statutes, DAOs are currently using this operating agreement to state that DAOs intend that their internal affairs would be managed entirely or partially by software. Expressly permitting members to do so could eliminate a degree of legal ambiguity. So in my mind, I don't see a reason why members couldn't come together and agree to this via an operating agreement, but that takes some time and expense to do that. If it was expressly permitted, that could make people feel more comfortable participating in these structures. And with these aforementioned changes or amendments, it would align with existing common law or other Wyoming initiatives, and would dramatically limit the time and expense of creating DAOs that are hoping to employ an underlying LLC structure. Conceivably, in the long run, and depending on the extent of any legislation, it could actually reduce or eliminate the need for a custom operating agreement. Right? If the default rules were set up in a way that the ecosystem is developing, instead of expressly putting together an operating agreement, the statute itself would provide the protection that folks need. Another area which is potentially worth exploring is clarifying when LLC interests for DAOs will and will not be considered securities. So DAOs can be structured in many different ways, but in general, they're structured to protect individuals and often employ a high degree of transparency. So via software, emerging DAOs are ensuring and are providing that individual members cannot disproportionately influence organizational decisions. So they're limiting the amount of ownership that any one party can have so that there's no majority owner. They're giving members, as mentioned before, the right to withdraw their capital at any point in time, limiting the ability of the organization to mismanage a member's assets. So being able to pull your assets at any point in time if you disagree with kind of the will of the group is incredibly powerful and not something that exists in existing organizations necessarily. And members can also hold DAO assets for a specified period of time. So to the extent that there's a concern about these being pass-through entities or some sort of entity where people can engage in abusive conduct, you can programmatically make sure that those assets are locked up for specified periods of time. And obviously some folks may choose to do that. The issue here is, whether LLC interests or securities is an often fraught analysis, but it tends to turn on whether there is a party in control of the organization and whether there are information asymmetries. For many DAOs, this is just not the case by design. So as noted before, by design, they're limiting control so that no one party or potentially groups of party can control these organizations. all the information is critically available to other members via blockchain for analysis. And at the same time, there's strong minority rights that can be baked in to make sure that that nobody is particularly hurt if the group is deciding to do things in ways that don't align with an individual's interests. So a statute that codifies existing common law, which in large part memorializes what I just described, could help foster responsible organizations and help organizations manage legal risk. Whether or not interests in DAOs are tradable at some point is a separate issue, but I think these definitional questions are critically important just so people can understand what they're walking into, deal with issues related to tax and a handful of other issues that come up as people explore these types of topics. And I guess the last piece, maybe I'll turn to you, Chris, or do you want me to run through this one?
Sure. So, a little context. I've been trying to myself create DAO or DAO-like organizations literally since 1988, before any of this was named, before a smart contract was done, et cetera. And I have been incorporating under Wyoming law a number of different of my own personal organizations and also helping other people in Wyoming to do so. And I've run into a number of different difficulties or challenges, some of which we talked about above. But also I think there are some opportunities for us to maybe create a new form of registered agent. Right now, we have two forms. We have the individual registered agent, who is just a Wyoming citizen with certain qualifications, can be the registered agent for a corporation. But then you can also apply and register with the Secretary of State to become a commercial registered agent. And you must do so if you're going to do it for more than 10 companies. It could be worthy, having worked with a number of registered agents, both the independent ones, but also the ones that are attorneys. We're not quite making it easy for people to bring business into Wyoming. And I think we could do a lot better. And by allowing registered agents to do other different types of services, that might encourage not only a local business of these digital registered agents or digital corporation registered agent, I don't know what the right name is, that can offer more services. So one of the things that they could do is actually maintain the name and addresses of the applicable members to limit DAO centralization. So one of the problems you have with a registered agent and the corporation is the corporation still has to keep all the records of how much people own, what percentages, who they are, and all that kind of stuff, which means there's sort of this centralization where the privacy of the members could be disrupted or not be what the members desire to have. Instead, the agent could act as a holder of this information, not only for the government in the case of service, which is what they have to do right now, but in for other purposes. And in general, protect the personal identifiable information of the owners. This could potentially be related to data repository trusts, which we've talked about before. How can the owners, protect them, their own interests as owners, and be able to have the kind of autonomy of how they make decisions and what ways they make decisions. But other things that one of these special registered agents might be able to do is be able to pay taxes on behalf of the DAO, offer escrow services and other financial trust or fiduciary services without being considered a money transfer agent. I think, one of the big concerns is that, these parties, want to be able to offer this type of stuff, but they don't want, they're just acting on behalf of the DAO as their representative, as their agent. but they don't want to be construed and be under the obligations of being a money transfer agent. So there may be other things, but this was, one idea that was tossed out to make that, might really make it easier, in addition to, regularizing the other stuff. I want to speak quickly to that. I personally believe that the kind of DAOs that I'm interested in, or LAOs that I'm interested in, pretty much can be done completely within the standard common law around LLCs and court cases around LLCs, and the the two bills that you have extended digital protection and digital capabilities for. That being said, it's not easy. A lot of that common law, a lot of those court cases and things of that nature are not all collected in one place. I'm finding I'm having to educate every attorney about it, and the sort of defaults aren't although you're allowed to change the defaults don't quite fit. So it's been very, very difficult, expensive to in effect train an attorney about what is possible within LLCs, because they all kind of have their very constrained models for what an LLC can do. So literally on the order of $30,000 to get not even a high-end attorney kind of up to speed on what legal scholars and court opinions and all that kind of stuff allow a DAO to do, that allows the members of the DAO to do what they want to do. And some of these are pretty small organizations. I mean, I know a group of coders that basically want to do a voluntary minimum salary for all the members of their DAO as part of their member agreement. I know others that want to do various kind of interesting property structures around intellectual property. Kind of like what movie industry does, but not at the huge expenses and unions that a California movie structure requires. Having to train your attorney about this type of stuff is a big obstacle and is keeping them from bringing their business to Wyoming. So I'd like to see those addressed and have a long laundry list of my own challenges there. So Aaron, anything else?
Sorry, I was muted. I just wanted to add that in many ways, what DAOs are trying to do is take one vein of limited liability companies and make them programmable, so that we can explore programmable governance and different structures for these entities. Instead of having some hierarchical entity, a very flat entity, one where everybody's in it together, and you can begin to program hyper participatory, democratically rooted organizational structures. And like we've seen with Bitcoin and we've seen with Ethereum and other blockchains, being able to program money has transformed the world. Being able to program organizations will, in my opinion, be equally important. We spend a lot of time talking about assets, but assets really don't mean much unless you can put them to productive use. And being able to put them to productive use is critically important, both for the blockchain ecosystem, but also for society at large. And I think a safe place, a sensible place like Wyoming, which has already taken the lead, has already become effectively the Delaware of digital asset law, I think would really solidify Wyoming's position, and also point to a future where these global organizations get organized in one place, right? So not just organizations that want to incorporate in the US, but folks anywhere from around the globe will look for the safest place to do this. And I think that that's a tremendous opportunity. So I think that's all my comments are. Thank you very much for the opportunity to present, Chairman Olson, and the rest of the committee. We really appreciate it.
Yeah, thanks, guys. I want to kind of tee off a little bit of a conversation based on some of the last statement. One of the last statements there from Mr. Allen and this can be for either one of you, but Mr. Allen, you mentioned training lawyers. Heaven knows we need trained. So, but my question is there enough in existing law in Wyoming? Because it sounds like there actually is. I don't know that there actually are legal impediments. There are some, but not legal impediments that completely prohibit someone from creating an organization that looks the way the two of you are envisioning it to look in the state of Wyoming. And so is it an issue of, as you put it, Mr. Allen, training lawyers to understand how to build a 21st century organization within existing law that already allows them to do that? Or are there enough legal impediments that to envision a truly decentralized organization built on top of existing, we'll say, LLC law, that we really do need something more than just clarifications in law?
I think it depends. I tend to follow the 80-20 rule. So given that, I think 80% can be solved completely within the current context. A little bit of education and maybe a little bit of saying, oh, the Secretary of State can accept this as a default, rather than the kind of current defaults, and a little bit of sort of regulatory guidance around some of the different opinions there. It gets a little more complex when you have more members. We begin to fall into risks of security interpretation of their membership interests. So we might want to clarify those edges. I think there are certain kinds of reporting and other things that we are allowing through the Secretary of State, but we might want to do more. We've already talked about the domicile requirement. We've already have law that says, hey, if your company has digital assets domiciled in Wyoming, but then we have no way for the company or the individuals in the company to prove that they were domiciled in Wyoming. So those kind of go hand in hand with some of the DAO stuff, where they basically want to say, we really want to be under Wyoming law for our organization. No matter the fact that, I'm a citizen of, Spain, and you're a citizen of Canada. We want to have our relationships governed under the rules of Wyoming and the Chancery Court of Wyoming, and we want to be sure of that. So some of those might require some specific improvements to the law. Aaron, you probably have some other, sort of like tweaks there as well.
No, I think I largely agree with that. I think there is value to articulating so that the public can understand what's possible. The notion that you have to go to an attorney and pay that attorney tens of thousands of dollars to understand how to set up a business or an organization just smacks me as not the right approach. And I think that in general, codifying common law to the extent that it can be codified is just sound policy, and it can really aid and benefit folks. And I think, as we all know, lawyers are incredibly risk averse. So just knowing that there's a statute that expressly states that they're permitted to do something is always helpful. It kind of eliminates that shade of gray that lawyers are always hoping to minimize. So I think it would be tremendously helpful. I think that that LLC laws in Wyoming and in other states can largely accommodate these structures, or at least give people the comfort to begin to experiment with this idea of actually programming organizations, much like how folks are experimenting with the idea of how to program money.
And then,
I think that's very powerful.
And excuse me, Mr. Allen. And one thing that I think of in particular that is, and Senator Nethercott or Representative Greer, you can correct me here if I'm wrong, but one impediment I think about is issuance of tokenized stock. So we have a very clear line drawn in law, as you know, that we can issue, you can issue stock as a tokenized certificate. The question is, and I've been presented with this over the years since we began this. I've had cold calls from around the country. Can I create a limited liability company and the membership be represented by a token? And maybe that, at one, I'm not sure that the Limited Liability Company Act says that. Well, I know that it doesn't say that you can't, but I don't know that it's clear enough on its own that you could represent a membership interest as a token. And so those are just some of the, maybe even if you get down to the real basics, as you begin to envision the ability to do this, an impediment like that at its very basic level would prohibit what I imagine most people would do with these organizations.
I mean, I think, part of the thing is.
Hold on, I'm sorry, Mr. Allen, Representative Greer.
Sorry.
So, Mr. Chairman, I guess my discomfort with the conversation is this. We talk about codifying common law with LLCs. Well, LLC is a statutory creature that exists. And the reason why people use LLCs is twofold. It's limited liability. That liability is created by statute. It is a fiction. Otherwise, you're in a partnership where everybody shares liability equally. Okay, the reason why we use LLCs rather than corporations is for tax treatment. Okay, now you can use a subchapter S and get treated the same way as a partnership, but it's not actually the same way because there are nuances with respect to the type of assets being held and disposition of those assets. LLCs are a pure partnership from a tax standpoint. So yeah, I think you can tokenize the ownership interest in an LLC. There's nothing prohibiting it at all. You still have reporting requirements though to the IRS. So what is the reason for doing this? Is the idea is to get away with any type of reporting requirements? Or is the idea to go ahead and skirt around the Securities and Exchange laws? Okay, what is the purpose behind this? Now also look at our LLC statute in total, okay? What it is a default. It has some basic guidelines to set up to be able to be registered as a Wyoming LLC. And then after that, it says, unless otherwise stated in the Articles of Organization or the operating agreement, then it gives how interests and how people will treat one another. But you can take your operating agreement and set it up any way you want. If you want to set it up so that you have 50 or 100 members and they share in every decision-making process that exists in law today, that's a member-managed LLC. Okay. If you want to set it up so you can pull your investment out or your capital out at any point in time, that's a clause in the agreement. So I'm struggling as what is a revolutionary need here, and I also need to understand what is the real purpose behind it.
Well, Mr. Wright, I know you were jumping at the bits to respond to why. Give Representative Greer the why if you can, please.
Absolutely, Chairman Olson. I think those are fantastic questions. I think the difference between why people are looking to LLCs as opposed to corporations, there's a presumption in a corporation that it's going to be managed not by the shareholders, but by a board. And with DAOs, many of the software developers are assuming that there's going to be no central manager. So the reason that folks are looking at LLC structures is in part what you described. It's not to skirt some sort of law. It's because that structure and member managed LLCs fit really nicely with that. And while it's completely true that you can, to a large degree, vary many of those default rules in the LLC statute via contract, these are folks that are not primarily dealing with contract. They're dealing with software. They want to order their affairs not with contracts, but with software itself. So asking them to go through the laborious process of putting together an operating agreement needlessly potentially increases the cost, or potentially needlessly increases the cost. And that's unfortunate, right? That means that there's less experimentation, there's less ability for these members to organize their affairs simply because they don't want to use something that they view as anachronistic, which is paper and natural language. They want to use software to basically achieve the same result. So it's not being done, in my experience and knowing the teams that are trying to explore it, like as Chris mentioned, he's been trying to explore these concepts for years for nefarious purposes. It's really just an extension of their expression of what they want to do in the public, and to do it without having some sort of board or somebody that's in control of them, and to do it in a way that that aligns with the laws of their state or their country. And I think that that's pretty reasonable. And I do think that providing some degree of clarity to folks that are in that position is a benefit. You shouldn't have to pay a lawyer $30,000, in my opinion, just to know your rights and to be able to start a business on top of all the organizational expenses, et cetera. So that's why I think I think that there can be some advantages to just streamlining and clarifying things. I will note, I don't think it's really a tax issue. It's not, people are not entering into these organizations for some sort of tax arbitrage or some sort of securities arbitrage. In fact, some of the organizations that have organized as LCs are presumptively assuming that those interests are securities, and I think reserving the right to make the argument that they're not in some capacity. So I think that that's kind of where the ecosystem's maturing. And obviously, there's lots of questions around that fact as well.
Representative Greer, did you have a follow-up?
Well, Mr. Chairman, no, I'm glad to hear there's not a nefarious reason behind it, because those are the questions I get asked all the time on these things. So I understand, well, I don't understand. So maybe that's where we are. I don't write code, so I don't understand. But the simple fact is that if you want to take advantage of those advantages of the laws of the state of Wyoming or Delaware or whatever state you want to, if you want to take advantage of the liability that's created, you want to take advantage of what you get from having a business entity versus just a loose association. All of those as they exist right now are in paper, okay? I agree, $30,000 to set up an LLC is a ridiculous sum. Your people need to hire Wyoming attorneys. We work together.
These are Wyoming attorneys.
So, but no, I just, I have a difficult time getting my mind around this concept and this particular need. And to me, for a group of people who are going to, and this is, and I've seen this where I've worked with it over the years, I'm not doing it anymore, but where someone may bring capital, hard cash to something, and then the other side of that coin was the intellectual property, the idea, the patent, or whatever was behind that. Those are agreements that people should come to and have a clear understanding of where their rights exist. That's how we do business. We look at the Uniform Commercial Code, which is a streamlined way of doing business in the US, and it works very well. And it is streamlined, but there still is that meeting of the minds, which is necessary. And so absent that meeting of the minds, I think you have something that doesn't work. And so that's my concern with it.
Senator Nethercott.
Thank you, Mr. Chairman. I have kind of a question, because I too have a hard time wrapping my arms around what we're trying to solve that can't be accomplished with current entity status now. So, I mean, I can have an LLC that says the software will run the day-to-day operations of the business, right? In fact, most of us have that in our daily businesses. So we can agree as the shareholders to do that. And I think maybe it might be my familiarity of working with and writing operating agreements with much smaller LLCs, right, including my own. And so I could see all the people every day that are shareholders and I work with in the business. And quite frankly, we could do whatever the heck we want to do, right? And there's no, we can change our document that dictates otherwise, and we can do that. So what I heard you say that I thought, okay, maybe that's the issue, is that you want to replace the decision-making of a board of directors, assuming you have a board of directors. I work with small LLCs that don't have boards of directors, right? I work with some corporations that do, of course, but I also work with most that don't. And because I represent a lot of small business. So I think the issue becomes there is supplanting the fiduciary obligations or duties of a corporate board to that of their shareholders. I mean, if that's kind of the legal question, you know, to supplanting that to an algorithm or to a software, I would say most of us are investing in that platform anyway. But as long as there's transparency, I'm not sure that that's forbidden, and particularly if there is kind of consent when it comes to that. So I don't know, and I'm just kind of grappling with understanding what it is you want to accomplish, because I don't quite get it yet, and I'll spend more time studying, and I don't want to be one of those lawyers that you have to beat your head trying to teach us. But there does seem to be a disconnect between a lot of smart people and a lot of other smart people about what the needs are. So somehow there's a miscommunication happening that we need to get resolved.
Senator Rothfuss.
Thank you, Mr. Chairman. I think one of the concerns here is, or concepts that we're missing is, with this is an autonomous organization in theory, decentralized autonomous organization. The idea, and no offense to our attorneys, is not to have an attorney involved. That's kind of part of the concept. Is once I have to start paying my $30,000 to start forming the legal structure that probably can be accomplished with all the right people in place and getting the right legal opinions and getting everybody engaged, I've already gone too far down the cash road for what a lot of the people want. They're coders. This is a community that wants to let the code do the work and execute in accordance with a set of rules that are built into the code that represents, it does, as Chairman Greer is discussing, I mean, it really is something that could be codified, and Senator Nethercott codified in the bylaws. There's no question. I think that you could take an LLC or a series LLC or whatever, and I could hire all of the attorneys on our committee and get you to sit down and bill me I don't know how many hours of time to get exactly what I want. And there's no way I'm going to do that, right? This is a community that we want, that wants to be able to be independent and come up with legal recognition for their entity that is autonomous. So again, the bylaws of the corporation are coded by them, not written on a piece of paper and then reflected in code. Coded by them. It's given legal standing in such a way that what is carried out by that code is legitimate and is recognized as legitimate. And then we need a structure around a legal support structure that gets to some of the points of what Chairman Greer was talking about. All right, so if we're going to treat it as a corporation, though, we're going to have to know who's involved. We're going to have to know how it looks so that we don't just create an entity that is rife with fraud. So it's the fact that not everybody wants to invest their, again, if it's a small software project, you've got 20 people, they want to get together in their free time on a weekend. Step one for them is not hire an attorney.
Senator Nethercott, almost jumping out of your chair there.
I mean, I heard that, and I ignored that because it's nonsensical.
Well, I've been nonsensical in your mind before, Senator.
Well, because all you're asking for is an LLC, and you can copy and paste whatever little code of rules you want to put in there. Boom, you're done. And Wyoming is the simplest LLC to do. You don't need a lawyer. And at most, it's going to cost $500. So, I mean, I don't know what you've been quoted for tens of thousands of dollars and whose those are, or $30,000, but that's just a fallacy. I mean, so and that's where I think there's just this major disconnect between copying and pasting. I can't create your rules for you. You're going to have to provide that to me.
Well, Mr. Chairman and
Senator,
Senator,
go ahead.
I'll
Senator
I'll
Rothfuss.
ask this then, kind of the counter side to it. If Senator Nethercott and Chairman Greer are saying that we can already do all of this in statute, this is fine. You could hire lawyers to do this. You could hire attorneys and get it done. What's the problem with it? Because it seems like there's a massive market out there. There are a lot of people that want this. And one of the things we're trying to do is create something where we see a demand in the tech innovation space. We see an interest from that community where they want something. And it seems like in their searchings, they haven't found the solution that is so glaringly obvious to some of us, and they still want it. So if we can basically do something which is apparently already enabled in statute, but call it a DAO, a DAO, and get people to engage with something that we're convinced you can already do, is there a downside to that?
And Senator Rothfuss, just to maybe add a little more information for the committee, and maybe Chris or Aaron, you can expand upon this, but Vermont created the blockchain, what do they call it? The blockchain LLC. So they thought they had kind of the in between fix. And I think they wanted to use existing law, but allow entities in this sphere to create their an LLC. And that's almost what I think Senator Nethercott and Representative Greer, I feel like the path your train of thought is on this Vermont blockchain LLC. And it's a flop because of what Senator Rothfuss is saying. And I myself am actually very skeptical of DAOs. I should put that out front. But I think it's a flop because of what Senator Rothfuss is saying, which is that the industry that wants this is not searching for the traditional LLC. They're not searching for a state like Vermont that says, yes, you can have an LLC. We just call it something different. No, they're looking to do exactly what Senator Rothfuss said. More than just I incorporate an LLC online. And because we're talking about a decentralized organization, it is birthed in a whole different way than a centralized organization might be birthed with a particular individual who sits behind a computer and initiates the filing. I know theoretically it's debatable, but I mentioned that the Bitcoin, in my mind, is the first DAO. And Senator Nethercott, where is that registered? It's not. There's not a state or a nation state that you could go to and find this registered organization that really is out there. It really has, with arguably members, it has capital, it's functioning as an organization. It's in large part, there are decisions that are being made because it's all in code. And I know a lot of people will disagree on whether that's truly an organization or not, but I think maybe that's, there's somewhere in between that Vermont model and this wholly autonomous organization that is Bitcoin, if you want to think of it as an organization. Senator Nethercott, please.
Thank you, Chairman Olson. I think that analogy, although maybe not perfect, is helpful to understand what the practical application of a DAO might be. But the distinction comes into me, Bitcoin doesn't have any liability protections. There's no built-in corporate shield. And so if a group, no matter how decentralized they may want to be, is seeking a corporate shield as granted by my state, there's going to have to be some type of compromise of who they are, right? And so if you're seeking something, you have to give up something, right? And so the difference of a DAO or the LLC is this corporate shield that's granted by state authority. And so how do I give this autonomous, decentralized organization the benefit of a corporate shield or an IRS tax filing status, right? That's the benefits there.
Representative Ian, you've been patiently waiting to jump in, please.
Thank you, Mr. Chairman. I think I feel like I'm going to back up a little bit, but based on Mr. Wright's slides, the biggest problem with our current statute is that the default rules are not what's the word that I'm looking for? Not the easiest to navigate when creating a DAO. So you could, in a corporate agreement, when you hire a lawyer, create an operating agreement that handles a lot of the rules, but instead it would be easier if in statute, we just copied and pasted the LLC statutes and then change the default rules and then call it a DAO structure instead of an LLC structure. I think personally that's a little silly. I mean, we could do it. We've done silly things to attract businesses before, and if it gets people to sign up, then I'll vote for it. However, maybe this is an alternative solution that I would ask the industry what they think of it is. We have nonprofit organizations now that come up with open source license structures to basically determine how you handle intellectual property in the digital realm with licenses that any layman could just say, oh, that structure makes sense. I'll just take this license and use it for myself. Why can't we have structures like that for operating agreements? So someone could create a DAO. Let's say I want to create a DAO. I don't know how to navigate it, but I will trust some nonprofit organization, maybe it's the Bitcoin Foundation or EFF, I don't know, anybody that created a bunch of open source operating agreements that says, you can found a DAO. If you want to found a DAO, you want to start a DAO, you can do it under Wyoming's LLC regimen, and you just use this version of an operating agreement and you fill out the blanks. Is that something that is a possibility other than us just recreating the LLC structure and just changing the default rules? Is that something that's necessary?
Mr. Allen?
So I've been trying, the very first meeting I went to was 2.5 years ago, in May or whatever it was. And I've been trying to get such an open source agreement, and I have some open source agreements. It has been very difficult to find attorneys that want to do that. I mean, I ran into some company, oh, we figured out how to make a DAO work when I was at the Jackson Hole one. And I said, well, you want to share it? And they said, no, we don't. It's our secret sauce. So there is a challenge here. And to make it, also to make it clear, we've talked about this as software engineers or whatever. It isn't completely that. It's millennials, okay? They have an inherent mistrust of authority. They want to be peers. They want to be equals. They have examples of people in their 20s being CEOs of giant companies who wear jeans and turtlenecks, okay? They want to find ways to be able to be peers together. And what they're finding is that the existing models, the standard contracts, the attorneys who do those standard contracts all want them to kind of conform to a non-peer type of thing. And especially in the creative profession. So we're talking about writers, artists, 3D creatives, game designers, novel writers, in addition to all the software engineers. And they want to be able to express these things in ways that, they can basically learn from each other, through things like GitHub and different tools of that nature, and go, I really like the way you did that, but you said you had a problem with X. We'll change X in our version of that. But that's not the way LLCs and operating agreements are shared in the world. So yeah, we can do this all outside, and maybe, each of you would be willing to, to pitch in a couple of weeks of your time. You're already pitching in weeks of your time to do this, to do this. So I think it's doable. Let's figure out some way to do it in either context, either the education draft side or in trying to have a default that is an alternative to this current default.
Well, as a millennial, I cannot attest to the need to wear turtlenecks, but I can certainly attest to my distrust in authority. whether that's because I'm a millennial or what, I don't know, but Representative Greer.
So understanding of this is key. I'm on this committee with an open mind. I think over the last couple of years, as this committee, without me being a member, has come forward, I've kept an open mind, worked on the legislation. I just want to make sure that what we're doing is necessary. I want to make sure that what we do makes sense. I want to make sure that when I get asked a question about what we're doing, I can answer it. Okay. So when I hear Senator Rothfuss talk about, well, it's, you know, the operating agreement and all that's in the code, and then the analogy being the blockchain, which I saw a very good tutorial on a blockchain and have an understanding of how that works. I'm having a very difficult time tying this together because you're talking about a nebulous collaboration. Okay, I don't think those can come together, those two terms. And they obviously do, as I listen to the people talk. The point is, though, and Senator Nethercott touched on this, okay? That's great if that's how you want to work. But when you come and ask for the structure, okay, and when you ask for the structure, it's not having a name being XYZ LLC, although that brings something with it. That brings a certain, aha, this is an entity that has an existence to it. That's how people think. Okay, but what that also brings with it is, you know, the validity of being something organized in this particular state, the state of Wyoming. It brings a certain amount of accountability for all those doing business with it, or all those associating with it, or all those having an ownership interest in it. It brings with it the protections of the laws of that state of Wyoming, the availability of the courts of that state. It also brings in a tax accounting, which unfortunately we all have to deal with the IRS in the US. I also think with that in mind is if you have this wonderful idea and somebody is collaboratively working on a code or an idea that becomes a product that is a wild success, it also brings a protection that I get to share in that success, even if I only had a small part with it, because that's my understanding going in. And so the question is do we just say, yeah, we're going to throw something out there that allows for a member managed LLC to be a DAO, because that's what we want to call it, and it attracts business to the state of Wyoming? That's fine, but we better have a little bit more. We need to, and it's a compromise. And I did this. So I started the practice of law in 1994, and I started out using limited partnerships because that was a known and understood legal entity. You know, since then I figured out ways to convert LLCs with the same type of structure as a limited partnership. And every time it took an education process with my clients to explain how that works. Okay, how do we get there? How do we get to that education process so Senator Nethercott and I, in our respective houses, understand this? Because we're going to put something out on the floor and I can't articulate that, it didn't go anywhere. So this is a hurdle we got to overcome if this is that critical to us advancing what has been the goal of this committee, and that is to stimulate a more diverse economy in this state. Guys, I'm just not there. You've got to bring me further along.
Miss Long, I don't like to put people on the spot, but having a technologist hat and a lawyer hat, I would really like for you, if you could, to chime in here and at least give us some of your thoughts on DAOs.
Okay, thank you, Mr. Chairman. I can't claim to have a technologist hat. I just have maybe a little bit more in-depth understanding of the technology than the average person, just due to the amount of time I've spent around it. But I am trained as an attorney, though I don't practice. So The way Representative Greer and Senator Nethercott, I would try to explain it, is that the groups of folks who want to set up these DAOs have, and by the way, they're doing it anyway, right? It's already out there. What they're trying to do is have the rules be enforced by the software rather than by the managers. So really what they are is organizations governed by software rather than governed by people. I would love to have Aaron give us, or Mr. Wright, give us some reaction as to whether that's really, whether he agrees with my assessment of that or not, but that's what's really going on. There is a mistrust of managers, of people, and they're perfectly happy to, they trust software more than people. And they would rather have organizations where they can audit the software and know exactly how the software is going to work. And there's just no subjective judgment that goes into the enforcement of those rules.
Mr. Wright?
Yeah, I think Ms. Long's interpretation is largely accurate, right? You're using software to create very firm rules about how an organization is going to operate. And these are folks that I think are well-intentioned, right? In part, I think they're looking for clarification because they want validity, right? They want to not just be a nebulous group that operates on the internet that isn't accountable to pay taxes and to take their responsibility. They want validity. They want to do it the right way. They don't want to be unincorporated entities. I'm sure many of them are happy to pay taxes to the extent that that's applicable and account for that because they're hoping to not do it on kind of the grayer part of the internet, but to do it in a way that's above board so that they can change the world in which they're living in. That's why they're forming these entities. And while there's many talented attorneys that may be able to put together the relevant operating agreement in order to enable them to do that, the fact is that these organizations are going to take lots of different flavors. They're going to go into lots of different industries and areas. And I think as lawyers know, that's going to require a degree of customization. And so as we described in the presentation, I don't think anybody's suggesting that there shouldn't be some sort of a legal backing behind this. And if that means that there's an operating agreement of some sort, I don't think anybody is necessarily pushing back against that, although I do agree that many of the software developers would like to whittle out the lawyers completely. But I do think that making it easier for that to be constructed, making it more apparent to lawyers that are working on this that they are able to defer to software expressly would be helpful. And I think that there's some advantages to that as well. There's a lot of difficulty that lawyers face when they have to basically interpret what the software is doing to memorialize it in an operating agreement. So they have to get down and dirty and really understand how the software works and all the mechanical steps so that they can accurately represent what this group of people want to do. And that takes some time, that takes some expense to do that in the right way. Sure, they could put some sort of vague notion that says all of our affairs will be governed by the software, but that may not protect their rights particularly well. They may need some additional clarification, a little bit more legal language around that. That takes a lot of time. That takes a lot of effort. That takes a lot of understanding on the part of the lawyer. I don't think that at this point it's something that you can just pay $500 and actually accurately capture what these software-based rules are doing. And I don't think that many lawyers feel comfortable saying that these software-based rules are going to dictate and know that their clients are not going to be left holding the bag if a court or some sort of body or one of the members challenges the validity of that structure off the bat. And that's a bit of concern. Same thing, we've had for laws, books on the books, statutes that deal with electronic signatures, yet the legal industry and the lawyers are not familiar with those laws still struggle to sometimes apply those in this context. So even though it's feasible, it's not necessarily apparent to many of the folks that are trying to bring these people into the fold, right? To validate them, to do it in the right way. And they don't want to be, again, these unincorporated entities where they're facing potentially tremendous amounts of liability for participating on, in something online. Why should you have to put all of your assets at risk just because you want to join a group of people to, try to build something or change something? And that just doesn't seem like a fair deal to me.
Representative Greer.
Yeah, so, Mr. Chairman, as I listen, again, this is a worthy endeavor to look at, but you look at, you organize as a member managed LLC. And then within your articles, you could reference, and so we'd have to double check this, but that the rights of the individual members, and that's how the rights of management, rights with respect to their ownership, are all governed by the code. And so that now you're looking just at a definitional component of that, and how do you get that defined? So that's a simple filing of articles, and leave it at that.
Yeah, I had the same, I have the same question that I think Representative Greer started with, and Aaron, I'll dive back to you in a second, but I honestly, and Senator Nethercott referenced this too, why, you can have an operating agreement in paper or you can have it in code. There's nothing in law that prevents anyone from doing that. You don't need a lawyer to go to the Secretary of State's website and file a limited liability company. So kind of check there. You could really write lawyers out of the whole system if you can do that. My hesitations with DAOs in the past have come with really the tokenization of membership, which is going back to my question of whether you could legally do that or not. But my hesitation exists in how much anonymity is then granted to the members at that point, because already anonymity is so high that you have an operating agreement that spells out who the members are, but the state doesn't know who they are. The registered agent knows who they are. The organizers know who they are. Possibly the attorney, if there is one involved, knows who the members are. Once you tokenize the membership, and it is zeros and ones instead of a person, and then it is so tradable, traceability gives me the concern. And so I guess I'll go back to Representative Greer's question, which initially seemed somewhat cynical, but I think is accurate. That is this about getting around security laws? Is it about getting around anonymity? Because I think from a public interest, this committee has an interest to be progressive and invite industry in. As Representative Yin said, we want people to come here and organize, but we don't want sex traffickers to come here and organize in the state of Wyoming. At least I don't. So there's a lot of organizations that aren't welcome here in the state of Wyoming, and there's a lot of organizations that are. So what really is at the end of the day that is so different here beyond just it being represented in code, because I think you can already do that. But Mr. Wright.
So I may just take that first point about just deferring with one line that the entire affairs of the organization are managed by code, and just highlight some of the shortcomings there. And the shortcomings come from an organization that started a couple years ago called the DAO, because that's expressly what happened with the DAO. They had a terms and conditions that said all affairs of this organization are managed by the software. Well, guess what? The software didn't work as intended. It had lots of bugs and issues with it. Some of the funds that were collected, and let's put aside the securities law concerns for now, it was drained. Nobody knew exactly what to do at that point. Why didn't they know what to do? Because they didn't clearly articulate all the rules related to it. It wasn't clear what could be done. So that approach actually was tried in the Ethereum ecosystem. That was the first approach, and it failed. It failed spectacularly due to securities law concerns, and it failed spectacularly because the code itself was not able to manage and mitigate those risks. And that's why there's a demand for these folks to not become these, unincorporated messes that are operating on the internet. They want to do it in the right way. They want clarity that they can defer to code-based systems, and they want to supplement that with provisions that deal with risk that they're concerned about. That risk could be a different calibration on the level of fiduciary obligation that they're going to owe to one another. That risk could be articulating rights that they have to withdraw funds, so that if the software fails, there's at least something that can back it. There's lots of other risks that they want to account for, and I'm sure as these organizations grow, those types of provisions will expand. But there is just some general questions as to whether or not they want to do this. And that's why I think folks are looking for a degree of certainty. And Chairman Olson, to your question about wanting to evade and questions related to tokenization, I'll just note that some of the smart contracts in the Ethereum ecosystem that are exploring this, there is no native token to those organizations. So in much the same way that we saw with the DAO, which ran into issues related to a question as to whether or not the interest in that entity was or was not a security. And the SEC determined that in a non-binding way in a 21A report that it was a security. These structures don't actually have native tokens. They really use a blockchain just to manage group decision-making. That doesn't mean that there's not an interest from folks to begin to represent interest in these entities as tokens so that they're tradable, so they can get fair pricing. There's lots of potential advantages related to that, but folks are not ready yet to go there, I would say. I'm sure in a couple of years that may be a bit different. But there is just a question as to what the heck are you getting when you join one of these organizations? Is it, do I need to organize as an LLC? If I do, does that make it a security in some sort of way? Does it not? If it's highly participatory, the case law related to that is, buried, in 100 or so cases that you have to scour Westlaw or LexisNexis in order to get to the bottom of. And that's confusing and concerning, and lawyers are going to, potentially have questions about the right way to go there. And I think in terms of being anonymous, that's exists on a spectrum. I think that some of these organizations have a high and desire a high degree of anonymity. Other organizations, they're going through compliance checks. They're keeping track of who's a part of them. They may not be disclosing that directly to the public, but if there's a question related to the business affairs of that organization, actually getting them to organize as legal entities is helpful in that, right? They can maintain those books and records. They can be identifiable. They can be subpoenable if there's an issue related to what's going on. People can serve process on those parties, and they can respond to things. So instead of being this unaffiliated and unorganized mess online, they're a known entity, right? They're identifiable. It's more orderly. They know whether or not they have liability or not, and they can proceed with their business affairs. And I think that that's pretty helpful overall. And whether or not there's a token in the picture, I think that that's really an open question.
Mrs. Long.
Thank you, Mr. Chairman. One of the things that it occurs to me listening to this that might help is if we keep the existing LLC law, but enable operating agreements to themselves be code instead of legal agreements. One of the challenges right now is that lawyers will work on things and then hand them off to a developer and say, go code this in and make this work. And you never really know if the code actually is reflecting what was in the legal agreement until something goes wrong. But what's happening here is now basically the legal agreement drafting is being skipped over, and essentially the nature of the organization is being written in code before it's written in legal agreements. What Aaron's asking for, Mr. Wright is asking for, is the ability to have those organizations that have their operating agreement written in code to get legal recognition. And maybe one of the ways to do that is to stick with the LLC law, but specifically allow operating agreements to be in code. And to the extent that there are disputes that judges in our courts have to try to work out, the code itself can be admissible as evidence. Maybe we can look at it from an angle like that. Just a thought. Thank you.
Yes, Senator Rothfuss.
Thank you, Mr. Chairman. I think Ms. Long is kind of on to the right path, which in my view is similar to what we did with digital asset custodianship. We map to clarity. We don't need to create anything new. I don't think. Maybe we do, but I don't get a sense we do. I think we have to point to parts of statute that apply. And I do think that providing clarification and saying a decentralized autonomous organization in the state of Wyoming is, and then we could say it is an LLC with these characteristics, with and we recognize code under certain circumstances filed according to whatever as being the legal equivalent of their guiding documents, something along those lines, where we provide clarity, but we don't have to invent an entirely new corporate structure. We just provide clarity and map our corporate structures to provide that clarity. And I would ask Mr. Wright if he thinks that's sufficient. He doesn't obviously know in fine detail all of our statutes, but does that seem like a sufficient solution to meet the needs of industry that they've been asking for? And I'll ask Mr. Allen too, who's been trying to do this for 2.5 years and hasn't gotten there yet. Is that going to work, or is that still going to be deficient? Because it seems like it meets some of the interests of Representative Greer and Senator Nethercott.
Mr. Wright, and I'll just real quick briefly tell you this is exactly how our working group conversation started. I tried to preface the entire conversation with that. There's one big policy choice in the very beginning, and I think we've gone down really the rabbit hole of the second policy choice, which is a wholly separate organization. Senator Rothfuss is asking about that first policy choice, which is this is built on top of existing LLC law. So a lot of the considerations, the concerns I have about anonymity, these concerns about tax law, concerns about liability, all of those things, I guess the conversation is whether those don't have to change if it's built on top of LLC law. But Senator Rothfuss, I think your question is exactly why we wanted to take this conversation to the larger group, because the question really is, does it do anything if you do that? How does the industry respond to it? We'll start with Mr. Wright, and then Mr. Allen, I'll come to you, just get some industry concepts there.
I think that being able to define at least, all or in part, the operating agreement and software would give lawyers and folks that want to put together these organizations some comfort. I think if that's coupled with clarification that certain books and records related to LLCs can also be maintained in an electronic format via blockchain would be helpful. To the extent that expanding some of the digital corporation related statutes to include interest in LLCs to the extent that they're identified as units or some other discrete ownership piece as tokens I'm sure that there will be folks in the industry that will ask for that. I know that that's a separate question, but I think that combination, along with some of the changes that Mr. Allen noted related to who's going to maintain the list of who's part of this organization, assuming they want to go down the LLC route, it could really be helpful. Because if not, then you have to have a party that's basically managing the whole thing, or at least administering it and playing a heavy hand and keeping track of everybody. So it would be nice to have a third party that could potentially do that on behalf of these organizations and obviously charge for their services, which would be, I imagine, something that they'd be willing to do if permitted.
Mr. Allen, how would industry respond to the ability to build such an organization on top of existing LLC law? And I had referenced the Vermont blockchain LLC. I don't know. Speak maybe to that and broader.
Yeah. So I personally believe it can be built off of current LLC law. I just feel like to really take it, we really want to provide, what they're seeking is constraints, okay? So they're basically going, we want to do as much as you will let us do. You know, you don't want us to be, you know, money launderers. You don't want us to be sex traffickers. You don't want us to do these other things. We're fine with that. We don't want to do that either. But what we would like to do is be able to have some of what, know where the edges are. Like, you know, it's been discussed here about maybe being able to sell your interest, you know, immediately when you're unhappy with it, but that might conflict with a security, being your interest being considered a security. They'd rather know definitively, oh, well, no, I have to hold it for at least a year or whatever so there's all these different things that I've discovered as a non-lawyer that happen in courts about interpretations and edges of what is possible in with an LLC operating agreement, and where you begin to get into territory that's either dangerous or gets you interpreted as a security or breaks your ability to not be mutually liable for everybody else's mistakes in the organization. They don't want to cross that. They want to know what the constraints are. I think you can define these constraints within the current LLC law. They just want help to basically say, yes, that's great. Here is a framework or whatever that does conform, that has our best opinions as to where some edges are that you shouldn't cross. And here's some areas where you have a lot of freedom. And then go, you know, have at it. And I think you can do that all within the LLC law now, especially with the two additions that the 2018 and 2019.
Senator Nethercott.
Thank you, Mr. Chairman. So what I'm coming at this as I would a lawyer with a client, and my goal is not to make money, and my goal is not to try to regulate or tell you no. My goal is to understand what your needs are so I can solve it and give you what you need, right? So I'm really listening very carefully. And I just think that there's probably some realities that we need to accept, understand, and let go of. And one is the security piece, which I've heard both of you mention a couple of times. We want to call it a token, and we want to maybe give this ownership interest in the business away without it being a security. Is it LLC a security or not? And case law is up in the air about that. And the answer to that is it's really not, right? But I cannot give you a corporate entity status or an operating agreement to where it's not a security. By calling it not a security does not make it not a security, right? So how it's used under the Howey test, and that's that case law that you're familiar with and has been the law of the land forever. It just depends on how it's used, right? And that's that factoring test. Doesn't matter what you call it, it's how you use it and how it is used with others for whether or not it's going to be a security. So we need to kind of let that concept go a little bit and recognize that that is not within our power or control to either call it that in statute or within an operating agreement. If it's a security, it's a security. If it's not, it's not. Now, when we understand the other issues associated with that, though, I think what I'm hearing is this kind of larger corporate challenge of we're foregoing the public stock exchange, right? And you're actually wanting to issue a variety of shares, right? So those individuals who own a small fraction that they have contributed in some way versus those major players who have maybe contributed more. And how do we delineate that ownership interest in the entity or in an operating agreement, right? When it continually can be for sale or available, similar to a publicly traded company, right? Like I own interests in GE as part of my mutual fund. I don't own GE really, right? I don't have really a voting share, right? It's part of my blockchain, you know, my block of stocks that I own. So I think what it looks like, we're looking at something like that and trying to shove it back into this little corporate entity status. So I want to make sure we have an understanding of an operating agreement, which I think is very simply done and doesn't need any different statute, versus selling or giving value to the entity itself and how it is itemized, either in units or in shares, as we're most familiar with understanding them. So I believe the operating agreement can be readily and easily solved. 2 is really the issue concerning how we fractionalize this corporate entity in a value.
I don't think so.
And
I think that's the fundamental problem. I mean, it's part of it. but-
hold on, Mr. Allen, hold on. Senator Nethercott, I was just going to say, don't sell yourself short on the securities question. I don't want to take us down that path necessarily, but remember that this blockchain deal started with a question of what is a security and wasn't a security. That's how this all started in the state of Wyoming. And even though that seems to be well put to, yeah. I mean, the reality is, I get that it's also a federal question, and I get that, but you know, it doesn't mean that we can't influence that law. Mr. Wright, you gonna respond to give an answer to Senator Nethercott's 2 questions?
Yes, thank you very much, Chairman Olson. So just mechanically, actually, the software keeps track of ownership, however it's denominated. There doesn't need to be a token, as noted before. In many ways, the software is just really great accounting and record keeping technology, at least as used in this context. What you gain from that is the speed of pooling together assets, right? The big innovation that blockchain technology brings in part is that it turns money or other forms of asset and basically is only constrained by the block time it takes to transport them. So value can flow really quickly and things can be settled really quickly. When you add to that the real power of what DAOs are exploring, which is governance, so voting in some sort of way, setting up rules related to the voting, exploring different structures for how to reach consensus amongst a group. That's what folks are trying to do. So I'll give you an example of what people want to explore, something called quadratic voting within organizations. So different ways in which you can sum up voting schemes in order to reach a decision and allocate capital. Let's put aside the securities law issues. They're just giving it away as a gift of some sort. So there's no real question about some sort of investment purpose. And these structures already exist, right? People are already exploring this in different ways. Memorializing that in an operating agreement is difficult. That's a difficult thing for many lawyers to do. It's difficult to know how to structure that. And the primary purpose of why people would want to organize this DAO is, and potentially organize it as an LLC, is so that they're not operating in some sort of nefarious way. They want to play around with different governance structures, things that are really hard to do today because we have to tabulate it on paper, but become really easy to do when you move into the era of software. And they want to do that at the speed of a blockchain and not the speed of a clerk or a lawyer or somebody else. And that's what people are just hoping to do in large part. Now, I'm sure there's going to be people on the edges that don't, but that's not really my concern or folks that I would advocate to support. It's the people that just want to experiment with great technology, look at new ways in which we can move around assets at a much faster rate, look at different ways in which to sum human decisions so that we can make better decisions, and to do so in a way that they're not subjecting themselves to some sort of unlimited liability because they're a nebulous organization, or having to pay a law firm a tremendous amount of money because the lawyers are not as talented as in LLC law, or they have reasonable questions about whether or not they can use software to do this, what risks are going to happen if they go down this path, can they sign things electronically, what happens when they add a delegated voting scheme to some of the governance decisions, and that's managed by a smart contract. How's that going to work? What happens if somebody pulls capital and the smart contract has a bug in it that may impact how it's going? Those are difficult questions, and that's what folks are trying to grapple with. Thank you,
Mr. Allen. I was sorry to cut you off earlier, but
you're right.
Long before I was born, the legislature wrote these rules about how these meetings are supposed to be conducted. Zoom makes it feel informal, but I still have to try to kind of corral all the cats here, so to speak. Do you have, Mr. Allen, because we're running up against time here and Representative Greer has a question, Mr. Allen, I just want to, do you have anything to add to the response to Senator Nethercott's 2 questions?
Yeah, that's what I wanted to directly address it. So I think part of the problem is that, let's apply it to, this entrepreneurial group where the money, what they're putting in is not money. The assets might be very few dollars, but it's a lot of time. Okay. And you and I can't decide, I'm a professional security software engineer, you're a professional lawyer, and you've got political experience and background or whatever. We could maybe say our time's worth the same, but as an entrepreneurs, we may not be able to decide for a year. And what we want to do is at the end of not say it's 50-50 our company that we're working on together. What we want to do is have some kind of system, which might involve some voting of other people or whatever, that at the end of the year, that, my contribution really didn't make a whole lot of difference and yours made a huge amount of difference. And we kind of set up some rules ahead of time that said, hey, when you and I are in a dispute, our peers will kind of vote, and they're going to give me a little less shares or a little less interest at the end, and you a little bit more. And because it's in an LLC, we don't have to have an immediate tax thing. It's not like I'm giving you half my shares. It's just more that it's been adjusted. And we can do that under LLCs. So a lot of the interests of what these parties want to do is not about dollar assets or things of that nature. They just want to be able to create things together. Sometimes are intangibles and other kinds of contributions. And they want to be able to say at the end, we were all treated fairly, and we have our peers that help, keep us accountable, such that, later, and maybe you guys decide there's a sharp line, when there's, an exit involved that, you have to use some other method, and now we have to do Howey tests and whatever. But they just want to, before they get to that line, be able to self-govern and be able to have some choices. So that's my customer to you.
Thank you, Representative Greer.
Yeah, thank you, Mr. Chair. I just a couple of comments, and then I got to return the call here. So I was practicing law every year. I would always sit down and read through the LLC statutes because it's something I use an awful lot. I haven't done it for a year or two now. So just pulled it and looked at it. And I think it's worthwhile for us to look at the Wyoming LLC statutes because I think we're selling them short. We said an 80-20 rule. I think you're probably 95%, 5%. And it's just interesting, so an operating agreement, the definition of an operating agreement means an agreement, okay? Whether or not referred to as an operating agreement, whether oral, in a record, implied, or any combination thereof, plain and simple. That is about as broad as you can get, okay? Then you can come back in and on becoming a member. You can become a member by contributing capital or not, by putting an interest in or not. Everything that's in here, I think, needs to be looked at very closely because we may already have 95% of what you're talking about. I think the real question is, Mr. Chairman and Chairman Rothfuss, is how do we express this and explain it? So with that, I apologize, but I hung up on the governor. So I got to call you. So, okay.
All right. That sounds like a call that you want to return, Representative Greer. Thank you. Thank you for your comments. Wow, Mr. Kaufman, your timing's so impeccable. We're in the middle of the great legal debate on DAOs. I don't know if you're on the working group with us. We've introduced the topic. I don't know if you caught any of this, but there's quite a discussion going. I don't know if you have anything that you'd like to add. Certainly would welcome your input.
Mr. Chairman, I'm so terribly sorry about the bad timing of that case matter I had to attend to. So I've missed all of the discussion up until now. So I'm happy to weigh in with some thoughts for the committee. Obviously, I have thought a lot about this, but I know Mr. Allen, Mr. Wright, you guys have been talking to them. Obviously, they've got a good handle on this. And so I'm happy just to let things go, Mr. Chairman. I can weigh in as we go.
Well, Mr. Kaufman, it seems like the main sticking point where we're at right now is Senator Nethercott and Representative Greer believe that existing LLC law allows us to get pretty much where we want to be with these organizations. Representative Greer believes 95% of existing law gets you there. I think Mr. Wright or Mr. Allen alluded to maybe 80% of our law. You practice in this area of law, obviously. So just give us your thoughts on if I wanted to set up a decentralized autonomous organization, could I do that in Wyoming under existing Wyoming law? And to the extent I can't, what are the legal impediments that I butt up against?
Ready, go.
Succinctly.
Yeah, so Mr. Chairman, so a couple of things on that point, and we talked a little bit about some of these in our working group. And before I address whether the allows and doesn't allow, just so the group has the benefit of my train of thought on this, the thing I'm struggling with personally the most is the policy decision of how we treat these things from a liability perspective, because if you are to do this under the LLC Act, for example, then I have to assume from that we are granting them limited liability status, much like the same that you do an LLC. And, the reverse, so sort of backing into the problem I have with that is we have a tremendous body of law built around piercing the corporate veil and what that looks like. And what is an individual or entity's rights to get at the assets of an entity. And the whole point, the whole exercise of following, these formalities is to protect those assets from that piercing. And so to me, that's a really threshold question that I just haven't been able to come to some conclusion on in my own mind as to how these entities and if these entities get or deserve liability protection status, because we're trying to enable them to do. So under that train of thought, yeah, I do agree, Mr. Chairman, that in terms of the logistics and the mechanics of the entity, in our working group meeting, Mr. Wright made a really great point that a whole bunch of the issues that I should say governance issues that an entity like this might face could probably be waived, or if not waived, there's at least enough flexibility in the act to deal with. But to me, like I said, before we even get to that question, I think an important policy consideration is how we're going to address these and treat them from a liability perspective. Because if we like the idea of giving a DAO limited liability protection and its owners limited liability protection, that's fine. I'm not advocating one way or the other. We could make under the LLC Act, although that would obviously presuppose that we want these to be LLC-like and or treated the same as an LLC versus a corporation or some other entity. But if we don't want these entities to have the same liability protection, that to me involves a much different sort of analysis of what types of activities shouldn't these entities be doing versus what type of activities these entities should be doing. And what are those formalities or those requirements, those base operations in LLCs or partnerships even, to determine whether or not you deserve entity status. Does that make sense?
Yes, it does. Certainly, I think that, and we dove into that to some extent on whether we even had to really touch the liability conversation. And because again, the question, I think that the prevailing opinion of Representative Greer is that that's not really a question, because you can create this organization using existing limited liability company law in Wyoming, and therefore the liability that exists is the liability that the limitations that already exist in law. So the question is whether.
And so I guess what I would.
Go ahead, Mr. Kaufman.
Sorry, Mr. Chairman, I didn't mean to interrupt. What I was just going to say is, just to refresh everybody's memory on this point. The law in Wyoming, like it is in Delaware, is that if you are two or more people gathered for a common purpose to make money in any way, shape, or form, you're considered a partnership at law. And we have a whole body of law that defines what your rights and obligations and duties are as a partner. And so, make no mistake about it, if a group of individuals through code or any other mechanism want to create, they don't meet the minimum requirements of an LLC or corporation, they're probably still due a partnership treatment at minimum. The problem is in Wyoming and Delaware and other places, partnership entities get no liability protection, unless of course you're a limited liability partnership or there's some sort of registration associated with that partnership. So I do a little bit disagree with that comment. And sorry, Representative Greer isn't here because I'd love to hear more about what he thinks, because I'm sure he has some great insights on this. But just to say that, gee, that's not exactly how the law is designed to work, in my view. I mean, filing articles of incorporation or organization is certainly a step and a required step to be an entity, but our law is incredibly clear on the back end that to get the liability protection that the law affords you, you have to uphold those formalities. And they're slightly different for LLCs versus corporations. And then for partnerships, obviously there are no of those requirements or a partnership. And so the partners might have rights with respect to each other, but third party or outsiders don't have the same rights. And so anyways, I'm getting off topic here, but that's the policy direction that I'm struggling with respect to where we characterize these.
Senator Rothfuss, you had your hand up.
Thank you, Mr. Chairman. And Matt, one of the things that we discussed based on some of the conversation was the idea of, rather than trying to create a whole new entity, if we took what we have on the books for limited liability corporations, which Representative Greer, for example, thinks it's around 95% of what we need, and then just clarify what the other 5% needs to look like. So we've got an entry in statute. We say a decentralized autonomous organization in Wyoming is a limited liability corporation subject to the following considerations, or something along those lines. So we basically start with an LLC, and then we clarify some of the questions that you have where there might not be a bright line. We try and map out any of those considerations, and maybe it's not perfectly what's desired, but to the extent that there really is no alternative, that there's a demand for a decentralized autonomous organization corporate structure, this seems to meet most of the interests. Does that seem like a workable path forward as a means of maybe getting this started, recognizing that it might not solve everyone's interests, but it sounds like it solves the key ones that have been identified. What are your thoughts on that approach, Mr. Coffin?
Mr. Coffin.
Yeah, Mr. Chairman, thank you for the question. So I don't disagree with that there are absolutely a lot of elements within the LLC Act that could be utilized. And in terms, again, of sort of the nuts and bolts and mechanics of allowing an entity to exist and operate, absolutely, we can get a long ways there. But again, if we're going to loop back and figure out what those things are and what those problems are, if we're going to characterize or classify this entity as an LLC, for default purposes, again, that brings with it a lot of legal assumptions and connotations that I think, again, we just want to think through and make sure those are the right ones. And I'll be the first to admit, well, I've thought a lot about this, and I've talked to a couple of my industry contacts and worked with a client set to kind of think through this. I don't have a great perspective on the broad industry demand as to what the needs are for an entity like this. And again, I'm not sure if liability protection is one, but I'll just give you an example of one that we went through. I mean, in the US, when you organize an LLC, you can elect to be taxed as a C corporation, but the default or the assumption is that you're going to be taxed as a partnership or a pass-through entity. So that's obviously a federal issue that we have to deal with at the state level. In our Wyoming state statute, we have some different flavors of LLCs. You can actually be what's called an L3C, which is a low profit limited liability company. You can even, like the closed corporation statutes, you can opt out of some of even the additional formalities and be a closed LLC. And so there's some of those flavors of LLCs that we already allow. And if we're going to allow this DAO to be a, one of those subset flavors of an LLC, I absolutely think that there's a way to do that. Again, my point is we're jumping to the assumption that an LLC fits for a lot of the other applications. And again, that overarching liability piece, that we're going to go ahead and work under the assumption that these entities get that liability piece.
Well, Mr. Chairman, quick follow-up. It seems to me that therein lies the advantage, though. If you're going, that's one of the essential points, I think, to providing a product that would attract this community to the state of Wyoming, where if the objective, I mean, the objective of this working group is not just to create fancy new things. The objective of this work, of this select committee, excuse me, is to draw businesses and development and information technology and new technology to the state of Wyoming, and to provide an attractive framework that is comparatively advantageous to other places where they would otherwise domicile. So if we want them domiciled here and we want them to consider this their headquarters, so to speak, it seems to me that the limited liability aspect is one of the essential components. I don't know exactly how it's supposed to be characterized in the end, and there are far better experts on this select committee than I am about what should and shouldn't be incorporated into that. Maybe incorporated is the wrong choice of words there. But at the end of the day, that seems like it's one of the key features that needs to be there to make this a worthwhile endeavor. If it's just a kind of an ad hoc partnership that falls back on existing federal law, then no one's going to be attracted to that. So it seems that and I'd ask Mr. Wright as well what his thoughts are on that, but it seems like one of the that a baseline LLC and then figure out how it works as an LLC becomes an attractive corporate structure for industry, but less than that probably isn't.
Mr. Wright, response to
that? Go ahead.
Sorry, was there another comment? I just didn't want to interrupt anybody.
No, possibly Mr. Kaufman wanted to respond, but he's frozen in time right now.
Okay, just wanted to check.
Go ahead.
Yeah, I do think the limited liability is the attraction. I think a lot of folks understand that the regulatory landscape for blockchain technology has evolved tremendously since 2016. They are coming to full grips with what other regulators are doing when it comes to securities laws, and doing their best to navigate the guidance that's been provided at the federal level. But when they look at early DAO experiments, most notably the DAO, there was a second issue, which was not characterization of whether or not the interest in that entity was a security, but it was a liability, because things went wrong. Putting aside those security law questions, millions of dollars were drained from that organization, and some of the participants in that organization had other assets. And if they were an implied partnership, arguably those other assets would have been put at stake as well. And when thinking about professionalizing some of these organizations so that they aren't these nebulous groups, but are operating as legitimate organizations and trying to improve the society in which they operate, knowing that they're not going to put their other assets at stake, I think is important. And what that means is, instead of getting organizations that you probably would not want to have organized in a state, you are going to get more professionalized, more sophisticated organizations that would choose Wyoming as their home. And even though there may be issues with Vermont's BBLLC statute, talking to developers when they're thinking about DAOs, they say, oh, I should organize a BBLLC. And then it's up to me and other lawyers that happen to speak with these folks to be like, well, there's not really that much that statute provides for you. And you may just want to just choose an LLC in another state as kind of a baseline. But it's not a perfect fit, right? Whether it's 80 or 95%, there's still room for improvement. And I think that improvement would be helpful to attract that business. I will note that it's not just in the US where there's activity that's going on here. other kind of DAO-like structures are being set up in the UK and in other jurisdictions around the globe. And so I think there is going to be a bit of a race to see which jurisdiction takes it kind of writ large, whether not a specific state, but will the US lead here or will some other jurisdiction lead? My preference obviously would be for the US to lead here. I think there's a lot of advantages that we have here.
Well, committee, let's do this. We've been at this particular topic since 3 o'clock, and it's been a great discussion. I don't want to cut off discussion necessarily, but discussion can continue until midnight tonight, or it can continue as we move forward. And so committee, I guess my question to you is, what do you want to do with this topic? Is it such that there's enough of a conversation here and enough to figure out that there may be something here that we can do for Wyoming? And if that's the case, then maybe we make a decision to move this forward, continue the working group, draft Representative Greer into the working group, of course. But if as a committee you sufficiently feel that there is nothing for this topic to offer the people of Wyoming, then let's not continue eating up the people's time, and let's devote our energies to some of the other topics we have. But we could talk about it all night long, and if that's what we want to do, then it sounds like we need to move the topic forward. But I'd love to, let's just go through the committee here and give me your flavor, your temperature on whether you even want to continue this conversation or you think it's dead here. Senator Nethercott.
Well, I don't think it's dead, and I don't want it to be dead. I do think that this conversation this afternoon, despite its challenges, was productive. I do expect more from Mr. Wright. You come with big credentials, so I need you to narrow it down what you think we can do in a smaller chunk, potentially, so that we have a solid grasp of what we're doing and why we're doing it. So let's start maybe with a simpler DAO and see how we could make it a corporate entity, right? I mean, let's use a real live case example with a real live DAO that's up and operational, and how we would make it a corporate entity in Wyoming. And let's work it through from a legitimate case pattern, just like I would as a lawyer. That's what I need to do, right? Because as the lawyer, I'm the one that's got to write the laws, to read it and then apply it in a meaningful way, or force you to write your operating agreement, which is more likely the case. But I do think we can continue to focus this in, but I think it might be prudent to break it down into smaller pieces.
Okay, Representative Greer.
I think just because I'm arguing or bringing up points doesn't mean I'm against an idea.
Sure.
And people have to understand that about me. I think it's worthwhile to continue to look at it. But I too, now I need things simpler. I don't need it to be a coloring book, but I would like a table. And I would like to say, these are the characteristics of a DAO that are necessary for it to function in a way that's useful. I need to have our Wyoming statutes that are there that already cover it. And then I also need to see what are the necessary changes in a little narrative to go along with why those changes are necessary. That's what I need to see. And quite frankly, that's what we need to have for our members. This is a relatively sophisticated committee, the membership here, and people with a greater understanding of business and in particular the law. When we go to make legislation, things get a little more emotional. So I think we need to be a little more clear cut on what we're looking for and what we need. And I also think it might help us scope our next discussion and maybe narrow the amount of time we spend on this. So, okay.
Helpful. I was going to ask Senator Driscoll, but that's not Senator Driscoll. That's Devil's Tower. Senator Dockstader.
Thank you. I would like to proceed with it, but I apologize. I missed part of the conversation. I had to switch over to a call with the speaker on broadband, now back to blockchain. So at this point, still willing to proceed. Agree with Senator Nethercott's approach that we have to separate it out and approach it that way.
Representative Yin.
I think having a real concrete use case of a story that of a DAO that wants to get started and what that means is really useful for the wide legislature if it gets past committee. So I'm fine with moving it forward, but I think both the senator and representative are right. We need to figure out how, if we move forward, how do you sell this to the full legislature?
Ms. Long, you had raised your hand.
Yes, thank you, Mr. Chairman. I was going to key in on what Mr. Wright ended with, which is that he's recommending to folks not to use the Vermont statute and instead to go set up an LLC in other states because the Vermont statute doesn't leave enough. And so I think if the concept is setting up an LLC, let's, Mr. Wright, it would be great if you would just even in an email, bang out what you think is missing from the LLC statutes. And that would just be a super help to this committee, which is struggling a little bit with trying to figure out exactly where to narrow our focus. And if the idea is that the LLC statute gets us 95% of the way there, then tell us what that other 5% is. I think that is definitely a path forward. And once we understand it, then it's easier to draft for it. Thank you.
Chairman.
Thank you, Mr. Chairman. I think we've got a good direction. I think this idea of analyzing our LLC statutes, figuring out what has to be tweaked or what has to be clarified or what has to be pointed to make it work as a DAO gets us, I think, a strong achievement without a significant change to statute. And I really do think that, once again, and this is one of the things we focused on in this committee, trying to be a meaningful first mover is really where our strength is. And I think this is an opportunity that we've elucidated today where we can do that in a way that we can have confidence in the statute and just figure out what those clarifications need to be. I do feel that it's essential, though, that we have a statute that says decentralized autonomous organization. It doesn't have to be all new. It just needs to be in statute where it says that is in Wyoming a LLC with the following characteristics, and then we come up with the clarifications from Mr. Wright that those characteristics have to be identified. The 5% that Representative Greer is talking about, what is that 5%? So I really think this is one of the statutes that we've looked at in recent years that has the most potential, because this is not just, it's not a Wyoming problem. It's not a national problem. This is an international problem where there is a desire to domicile products, so to speak, that might end up being highly lucrative. Now, we obviously have a rubbish tax structure that can't possibly capitalize on it in its current form. But if we were to have a revenue structure that we're capable of capitalizing on revenue that was generated within the state of Wyoming and income in the state of Wyoming, there's a lot of potential here. I mean, you think of the idea, Mr. Chairman, that this is probably how software will be packaged moving forward, how projects will be packaged. If you have the capacity to package them in this manner, where you can have an autonomous contract effectively leading to the governance of a piece of software, and there are pieces of software that are many billion-dollar revenue packages, and it might not turn out that way, but if we have an opportunity to be the prime mover, I think that's what this select committee is tasked with, and so I'm eager to pursue it, and I like the direction that the select committee has clarified, and it sounds like from our experts that it's a workable outcome.
Okay. Well, I've taken good notes on what all of you have pointed out through these 2 hours, and more specifically in these final minutes. So, and the chairman of this working group, although I'm not necessarily wild about the idea, I'm becoming more and more warm to it. So we're going to take these back. I'll circle the wagons with Aaron, with Mr. Allen, with Mr. Kaufman, Ms. Long, and Senator Dockstetter, and we'll continue. We will specifically begin to narrow and form a scope on this. I think having as Representative Yin said, really having a use case is going to matter when you get to the larger body of the legislature. And I really, really agree with, let's look at LLC law and just clearly delineate what we can already do, where we can do it, and what's the 5% that we need, and let's figure it out from there. So we'll circle back to the next meeting with more on this topic, and hopefully have it more narrowed for you, committee. Public comment. Public comment on DAOs. And Mr. Allen, you're already here. Certainly give us some public comment if you have it, but because it is 5:20, please do keep it as short and as succinct as possible.
Yeah, so we've been focused on the law side of this and the regulations and such, and I'm not convinced that there is a there that we need to fix that per se. But we are also chartered to bring business into Wyoming, and there are obstacles. I cannot go to any registered agent. I can't even go to a member of the blockchain coalition who is a registered agent and a lawyer and get what I need because he doesn't have the basic knowledge for it or doesn't understand what he can do. So I don't know if it's an education problem or whatever, but I, as an expert, am having a hard time getting my own company's properly operating agreement says there's a fundamental obstacle. So maybe the other agenda for a future meeting is how do we get rid of these barriers? And maybe it has nothing to do with direct law. Maybe it just needs, a white paper written by the Secretary of State that says, whatever, that's funded by some self-tax type thing. So, that's kind of my hope.
Thank you, Mr. Allen. Public comment on DAOs. Again, we'll have some general public comment when we finish up here. And I'm just checking my list here. Committee, give me a second. I don't have any scheduled public comment unless Kelly or David, you have anyone in the waiting room that you know is here for DAOs, we can let them in. If not,
I think once again, Mr. Meyer was on the list, and we haven't heard from him on it.
Is Mr. Meyer on the DAOs?
I think so.
Okay.
But he's also on the public comment, so we probably just give him a general opportunity and then get Mr. Cornish in as well.
Okay, yeah, let's get Mr. Meyer into the waiting room if he would like to give general comment about anything today, and anybody else that would like to provide general comment on any of the topics we've touched on today, let's get them into the waiting room, and we'll start with Mr. Cornish. Hey, Bob, we just let you in. There you are. You can go ahead and unmute and enlighten us. Bob, you're still muted.
You hover your cursor near the bottom of the window and it'll show up.
Yeah. Good afternoon, everybody. I know I'm standing between you and beer 30, so we'll be brief. Thanks for having me. A couple things I wanted to talk about. I did send Kelly a brief email on what I thought would be an interesting take and use of the SPDI structure especially in light of some events this past week. One of the schisms, I guess, that we have in blockchain and token regulation right now is the intrastate taxation, transfers, all that kind of thing. Of course, the other thing, of course, that Wyoming depends upon in for tax revenue is extraction revenue in the oil and gas and coal business. The question becomes, how do we encourage the extraction industries in Wyoming, such as oil, gas, and coal, to utilize the blockchain and tokenized media that we have available in the state? Namely, how do we get oil and gas companies to leverage what they have in the state, such as oil producing properties, so on and so forth, and to create tokenized interest in those properties, whether in the form of securities or in interest in minerals themselves, somewhere in that way. Just looking at the statute, I'm not a Wyoming tax attorney. I am admitted in Wyoming. I do not profess to know the history of the extraction tax structure in the state, but we do know that the governor has abated tax on extraction from 6 to 4% in light of recent market issues. The oil and gas markets are not, I believe, wholly representative of the true prices of materials. The fact that you have backwardation in the futures market that ultimately created negative oil prices, I think is somewhat, it's a product of speculation. I think if there were a way that the state could encourage the oil and gas business to utilize SPDIs as vehicles for tokenized vehicles, either securities themselves or interest in the properties themselves, I think you would actually have not only a business, you would not only jumpstart a business in the SPDI world, notwithstanding what's going on outside of Wyoming, but you would also be able to assist the oil and gas business in monetizing assets and perhaps creating a market. So I did send Kelly a brief structure. I don't know what the rate would be that you could give somebody a break on if they decided to tokenize their oil and gas producing property. But I think it is something that, in terms of being centered on job creation in Wyoming and I guess preserving purpose of the SPDIs, some incentive for the oil and gas business to tokenize, I think, would be a very good thing for Wyoming. That's all I have.
Excellent. Thanks, Bob. Senator Rothfuss.
Thank you, Mr. Co-Chairman. Bob, I just wanted to say we appreciate that, this idea that's sort of thinking outside the box, and we'll give it some thought. We have conversations at the Minerals Committee in that realm. Maybe there is some way that we can get this overlap. I appreciate that thought.
You're welcome. It is the one area in the legislation where we do have all this tax protection for digitized assets, and it's unclear if you go through all the tax statutes for the minerals side whether it really applies. So why not make it clear, or at least give them some incentive and get some jobs in the state?
Thank you.
Perfect. Thanks, Bob.
You're welcome.
Other public comment, Kelly and David, is there anyone else we're missing in our waiting room?
I actually do have one thing I would like to bring up, if I could.
Yeah, go ahead.
Thank you. There are several, I know we've talked about this amongst in other meetings, but there is a question out there about whether attorneys within the state of Wyoming can accept digital assets for payment. It would seem to be, at least in maybe someone else on the committee can with the state bar association or the Supreme Court. But I think the best thing that we might be able to do, as you all might be able to do as a committee, is perhaps write to the state bar for an opinion, saying whether it should be, whether digital assets could be acceptable for the payment of legal services in the state, and work it that way. I think it would just be nice to have that ironed out, given all the great things we've got in the state of Wyoming, that attorneys within the state can actually conduct business using all this stuff.
It's an interesting concept to, I mean, I don't know if I've never picked up the phone and called the bar council and said, hey, am I violating an ethical rule by accepting cryptocurrency? I don't know if Matt or Tara, you have, but anytime I'm confronted with an ethical question, I don't necessarily ask the bar to give me their opinion on it, right? But it's an interesting concept, Matt.
Yeah, Mr. Chairman, I have done that, and I've discussed it with bar council a few different times, and the guidance that in my circumstances, and it's been on more than one occasion, I got guidance that the ethical rules for attorneys very clearly say that you can barter and exchange any form of property for payment, and digital assets being one of them. And so there is no bar. So, I mean, I don't know what attorneys are telling their clients, that they're not permitted to take cryptocurrency, but I'm not sure why, because I've taken payment via cryptocurrency, and I'm certain that through our bar, it's perfectly acceptable and ethical.
Yeah, Matt, that's where I'm at. The only other caveat I would add to that is after you check with the spouse. One time I tried to barter for a piano, and I thought it was a really brilliant idea. Then I asked Danny, and she said, that's not a good idea, Jared. We can't feed our family. But yes, you can barter. You can take any commodity you want. Tara? Senator Nethercott, excuse me.
Yes. So the lawyer that you're dealing with or are dealing with, they just don't want to take it because they don't know about it. It takes work and effort. They don't use it. They don't want to use it, right? They want cash. They just want cash. But yeah, I mean, I've taken gold Krugerrands. We've taken all kinds of property, and we take thousands of dollars in straight green cash in large lump sums, and we don't ask where or how it came from, right? And so all lawyers do that, and they'll continue to do that. They don't care about Bitcoin. It's just extra work and time for them to turn that into cash, and they're not interested. They'd rather have you do it and then pay them the cash.
Mr. Chairman, Senator Nethercott, to quote you, I think you may have said too much.
Perfectly legal.
Oh.
Everyone
piles of cash, piles.
Here I am taking a little piano, and Senator Nethercott's taking stacks of green hundreds.
Make them sell the piano first.
Krugerrands. Yeah.
$3,000 for the LLC.
You got to report anything over 10 grand. Remember that.
Depends when they come in. I've acquired property in Florida.
Yeah. Well, there you go.
All right, Mr. Chairman, we should wrap this up. 5:30. Yep. Let's close.
Wrapping it up. I don't have any other public comment. Before we close it out here, though, I do want to turn to David and Kelly. David and Kelly, you can tell us if we missed anything. If you need any additional direction from us, we haven't asked you to, I don't think we asked you today to draft anything, but please tell us if we're missing anything.
Mr. Chairman, I think you got it all.
I would agree. As far as I know, there wasn't any drafting requests. So if that's wrong, then let me know.
I think that's right. So I feel like we got these working groups out there. These working groups, feel free to incorporate David and Kelly into your working group, because if you're developing some legislation, there's nothing wrong with that and bringing it back to the body so that we have something to actually look at when we're beginning our conversation. Doesn't mean we're voting on any bill. It's just a place to start. So feel free to do that. And that's all I really have, Mr. Co-Chairman.
Yeah, absolutely. And I do think that I hope we will start working on some of the drafting and getting some preliminary drafts, even though we don't have specific requests. I think we all have a concept from each of the working groups of what those should look like. So I hope we will start getting those drafts ready, even though we weren't explicit on the drafting requests as a product of the working group. We will have another single day meeting in August that's already scheduled. We'll, for the most part, be going over different topics, although we might touch base and just give a couple of minutes to each committee if there's anything as far as updates at that meeting.
Very good. Committee, anything else for the good of the body or the good of Wyoming? No? All right. Well, we'll sign off. Thanks, everybody. For your
Thanks,
hard
everyone.
work.
Great work.